Uh-huh.
Yes.
Item 1, PIL Sumoto 1/2020.
Yes.
May I please, your lordship?
Yes.
On last occasion, that is on 17th of
After a lot of hearing, maybe it will not be so pleasing now. Yes.
I believe all the parties have made extensive submissions. And on the last occasion, lordship has fixed today for further hearing. And I think my learned friend S. Doctor, he has not completed his reply. In the course of that, we have stopped. Otherwise, all the parties have made extensive submissions, lordship. After my learned friend submits, I would like to conclude by taking about 10 minutes time for concluding the hearing, lordship. And hopefully today we'll be able to conclude. And with one understanding, better is the end of a thing than the beginning. Beginning is also important, but it matters how it ends. The ending is very important. So today being the last
All well that
day of
ends
the
well.
hearing,
All well that ends well.
with that understanding, I came to attend the concluding hymn and the benediction prayer. I learned it when
Lord, Lord, just take one moment, because I have a slightly different submission than what falls from what my learned friend makes, Lord.
Yes.
My Lord's permission. Lord, in fact, my Lords have heard this matter extensively. It was supposed to be reserved last time. Lords, everybody, the order categorically records. Lords, I've concluded my submissions. The learned AG has concluded his submissions. The Amicus has concluded his submissions. Mr. Datta had also, Lords, made his submissions initially. We had responded. Rejoinder is also over. This sir rejoinder and then another rejoinder. If they make submissions, then the learned AG may say, I have something to say. I may say, I have something to say. This will go on in extenso forever. I implore that matter should be reserved. Everybody has filed their written submissions. That is more than enough. Ultimately, there's so many times that we cannot just submit, but there's so many times we can just repeat. Now we are just repeating.
I
First
agree
end.
with the submission of my learned friend.
But ultimately, Mr. Kohli, in a lighter note, at times these houses of people
Yes.
manned by good lawyers. So
Lawyers will never be satisfied. Lawyers will always have something to say. Ultimately, my lords will have to take a decision and stop it. I'm only saying that, lords. I leave it to my lords' better judgment. But really,
Appropriate to conclude with about 10 minutes time by amicus curiae, as amicus curiae. I feel that that will be reasonable.
yes, Mr. Datta.
So far I am concerned, my lord, I have already concluded. My lord, if I want to say something, it will be, my lord, repetition of the old things. So, my lord, since I have completed, my lord, I don't want to say any further.
so the learned Amicus had also finished it last time. In fact, his was the last submission. It should be.
Yes.
With your lordship's kind permission, my lord,
Yes.
I couldn't make it there because of certain health reasons. I'm only saying if required, I may take 2-3 minutes, not more than. I've already made the submission.
How's your health? Somebody told me that you were hospitalized.
Yeah, I underwent a sudden emergency procedure. It was unexpected. I had a 90% block.
Okay.
So I've just been discharged 2-3 days back. That's why I could not come, but I did not want to seek any adjournment. So I thought I may take a few minutes, that's all. If your lordship permits.
The only thing I would like to refer one IA application your lordship will find. 1538. Subject to the outcome of this.
What is this IA? you are praying for an extension of
My lord.
that
Exact
contract. That is
document
the
I'm
prayer.
giving up to your lordship.
We are aware of. Mr. Jamini, before you begin, let Mr. Balgopal needs
Lord.
2 minutes.
Lord.
Yes.
Please, my lord. Without going into not repeating any of the submissions made earlier, I thought I would only point out that the main contention of Union of India last time has been that no decision to the contrary has been furnished by the state or anybody else to the effect of the supervening influence of the entries in the central list. That is one part on which they are banking. Parallel to that, they have also not touched upon the intention of the legislature, which is very important for this honorable court to decide the matter. I have also discussed, my lord, already what is the intention of the parliament. It should take into consideration various historical facts, etc. And all these submissions are already on record. I have also made 2 judgments, my lord, yesterday night for your lordship's kind consideration. My lord.
Yes.
One of the judgments, my lord, referred in the earlier judgment, has been referred to in the judgment of Honorable Justice Gawai, Honorable Chief Justice Gawai. No, it's I'm sorry, that is Macquarie Bank versus Shilpi Cable Technologies. Civil Appeal 15135 of 2017. I have mailed it, madam. It's on the mail of your lordships. 2 copies I have made. And the relevant paragraph is page 43 and 44.
Paragraph 43.
I'm sorry,
Page.
page 43 and 44. May I just read a few lines if your lordship would permit me, my lord?
Yes.
Yeah. The task of a judge when he looks at the literal language of the statute, as well as the object and purpose of the statute, is not to interpret the provisions as he likes, but to interpret the provisions keeping in mind Parliament's language and the object that Parliament had in mind. With this caveat, it is clear that judges are not knight errant free to roam around in the interpretative world doing as each judge likes. They are bound by the text of the statute together with the context in which the statute is enacted, and both text and context are Parliament's and not what the judge thinks the statute has been enacted for. Why I am referring to this judgment particularly because the interpretation that is being sought to be given by the Union of India in this case
Please continue.
in
The interpretation.
the interpretation that is being sought to be given by the Learned Council for the Union of India. In fact, even when the learned judges cannot, express their independent intervention, the intervention should be part of the Parliament. On these facts, he has been totally silent. The next judgment, my lord, is that the judgment. The next judgment, my lord, is where is the second judgment? The next judgment, my lord, is ERA through Dr. Manjula Kripendorf versus State. That is 2017 SEC Online, SC 787. Para 139.
2017 SCC online page.
2017 SCC online, SC page 787. This judgment also I have given, my lord. Only 4 lines from this at para 139, middle of it. May I read 4 lines, my lord?
Yes.
The middle of it, in short. My lord has got it, both my lords have got it.
Please continue. We'll have it in the.
Well, in short, the difference is the well-known philosophical difference between is and ought. Thus, the judge put himself in the place of the legislator and asked himself whether the legislator intended a certain result, or does he state that this must have been the intention of the legislature and infuse what he thinks should have been done had he been the legislator? If the latter, it is clear that the judge then would add something more than what there is in the statute by way of a supposed intention of the legislature and would go beyond creative interpretation of legislation to legislating itself. It is at this point that the judge crosses the Lakshman Rekha and becomes a legislator, stating what the law ought to be instead of what the law is. This again I am referring to this judgment, not with any other purpose. This is the type of interpretation the Learned Council for the Union of India has been given. So there is a little bit of caution that has to be seen in these type of circumstances, I think. Type down. Then, my lord, just as the sake of repetition, my issue of ownership, transfer, land and resources, that ownership part has been considered, that has been settled. Therefore, as far as 121 is concerned, that's a different thing. But, my lord, on the ground, this is the point I want to state. Though there is tacit admission in the court and on the basis of documents that these regulations don't touch upon the ownership and transfer of land and its resources, on the ground, it is a different story, my lord, where they have themselves in writing claimed to be the alleged owner of the land. I have given the 2 agreements. Not only that, they have also expressed their intention to transfer the resources.
That part you have already submitted.
Just this portion I have not transmitted, which I am going to submit now. They have intended to transfer. Oh, just a minute, my lord, kindly bear with me. Only one. Transfer the resources without the legislature permission. That's all I'm saying. I won't say anything more than that. That's the other point I wanted to say. Then apart from that, my lord, I don't think there is much to be gone into, because in my written submissions, my lord, point to point, I'm not repeating that unless my lord wants any clarification on any aspect. I have discussed the entire issue, and even I have also clarified last time, which I could not clarify, because your lordship said that as far as 54 is concerned, entry 54 is concerned, the legal opinions are dealing only with 54, but the Attorney General's opinion deals with 53, and the Foreign Secretary is between 53 and 54. I'm grateful to your lordship.
Yes.
Then any other clarification I'm here to give, my lord. I don't want to re-argue the matter. I have put everything on record.
Yes. For the
Yes,
High Court, you have to say anything?
Lordship, I've already submitted my written submission.
Yes.
Emailed it on the 27th, Lordship. I have nothing more to say. My role as a standing counsel is limited, Lordship. So I've already submitted my just
Okay. You had mailed it on 27th.
Yes, Lordship. It was emailed.
Okay. Yeah.
Whether that is available or not on record.
No, we don't have it.
Then, Lordship, I may be permitted to resend it again, the same copy.
No, we have it. We have it. Since we did not know it, it's not downloaded.
Oh, yes. All right. So I'll stick to the written submission that has been submitted, Lord. It's
Okay,
a short written submission. That's all, Lord.
okay. Yes, Mr. Jamir.
Please, your lordships. After we started the effective hearing, today, including today, it is the 16th day, 16th sitting. After starting the effective hearing, excluding other adjournments before the effective hearing, lordships. If I make any submission, then that will be only a repetition of what I have submitted earlier. But one point I would like to
Yes.
submit, which, if my memory doesn't fail, none of the councils have made submission on that point. And I feel that since it is a well-settled principle of law, it is not necessary to apprise this honorable court. Maybe with that understanding, no submissions may have been made on that point. That is a very commonly accepted principle. When two views are possible, the one which is in favor of the constitutionality has to be adopted. Now, during the course of argument, two issues have been crystallized. That is, it is the Union Parliament who has the power to make law on the four clauses. That is one issue. And the other issue is, no, it is the State Legislative Assembly of Nagaland to make law on the four clauses under Article 371A. These are the two conflicting issues we are confronted with. And coming to the laws made by the Parliament, I have not came across any provision that, in spite of the special provisions under Article 371A in the four clauses, in spite of this non-obstante clause, Union Parliament will still have the power to make law. I have not came across such things. And one thing is very clear, that yes, Union Parliament will have the power to make law, but such law touching the four clauses under 371A will be applicable only when the Nagaland Legislative Assembly by a resolution so decides. So it's not that Union Parliament do not have the power. They have the power, but any law made under touching the four clauses will be applied only when the Nagaland Legislative Assembly by a resolution so decides, will be applied. So that is very clear. Now, the another point which comes is, no, look, although there is a special provisions under 371A under four clauses, there is no specific stipulation in the article itself showing that the state of Nagaland, the Nagaland Legislative Assembly will have the power to make law on these four clauses. Since there is no specific stipulation in the article, specific mention in the article, it cannot be inferred or it cannot be implied that state legislature will have the power. These are the two issues. But as I have mentioned, there is no provision that in spite of 371A, Union Parliament will have the power to make law on this. There is nothing. Therefore, a presumption can be drawn. The one which is in favor of the constitutionality, that will be adopted. So article, if we read carefully the article 371A towards the end of after the four clauses, lordships will find, unless the Nagaland Legislative Assembly by a resolution so decides, so decides is the power to take a decision. To take what decision? To make a law under 4 clauses. Therefore, going by the interpretation of the provisions of 371A, I feel that 371A is in favor of the constitutionality. So that is what, that was not highlighted during the course of argument. So that is one point. The one which is in favor of the constitutionality, that is to be adopted. Now, on the day of registration on 8/10/2015, this Honorable Court, while hearing the writ petition, has made a tentative opinion that in the opinion of this court, it is the Union Parliament who has the power to make law in view of Article 246 in 353 of Unions. So it is the Union Parliament who has the power to make law on this issue. That was the tentative opinion arrived and formed on that particular day, that is 8/10/2015. This tentative opinion was expressed and formed without examining and discussing and deliberations on Article 371A. Now, during the course of hearing, during the last 16 sittings of the court for hearing of this case, what is 371A? What is implication? How it came? Everything has been submitted. So I'm not going on that. But the detailed deliberation and discussions have been made on 371A, how it came, and inserted as one of the articles in the Constitution itself. Therefore, the tax which is invested on this Honorable Court is to take a call, to take a decision whether the tentative opinion formed by this court on 8/10/2015 is correct or not. And subsequently, on 4/2/2019, the present suo motu PL has been registered as a public interest litigation. So this Honorable Court has to decide on that point whether the tentative opinion formed by the court on 8/10/2015 is correct or not. And once that is decided, a very important law, an important principle will be laid down by this Honorable Court, which has not been done during the last 63 years, after the article has been inserted in the Constitution in 1962, Lordship. I believe I conclude with that. I'm very grateful and thankful to God for granting good health to all of us during the last 7 years of the registration of this case. With that, I conclude. Highly appreciate, Lordships.
From the last order, to take the name of the senior counsel and counsel of the parties, including Advocate General and standing counsel for the High Court from who appeared through video conferencing. Mr. Vivek Kohli also appears through video conferencing. Mr. Balgopal, along with Ms. Nambiar.
What is the list of the names, my lord?
Yes, we are copying it from the last order, but I am telling her that
Right.
who are from, online.
Very good.
Counsel for High Court is online.
Yes.
Next para. There's a written note of submissions. Damien, written note of submissions by High Court's counsel on 27th.
Yes. 7 now. Yes.
On 27/6.
Yes.
Standing counsel to my amicus curiae. No, standing counsel's argument is not there. It's not available. No, standing counsel for High Court. He's from.
He's from Kohima.
He's from Kohima.
Yes, sir. Yes, sir.
His submission said. His submissions were sent on 27/6. Get that and
It was emailed on 27th.
27/6.
Yes, Lord.
Okay. Next, in the interregnum, written submissions have been submitted by the learned amicus curiae on behalf of as well as on behalf of respondent number 7 and respondent number 8, as well as by the learned standing counsel for the High Court. Further oral submissions have been made by Mr. S. Datta, learned senior counsel for respondent number. You will be for respondent number 7. Respondent number 7. Mr. Balgopal, and Advocate General for the state. And reply submissions by Mr. C.T. Jamit and his senior counsel and amicus curiae in the matter. Next paragraph. Arguments are concluded. Next paragraph, judgment is reserved. First of, however, the next paragraph, as the matter has been heard for 16 days, spread over a long period of time, comma, in the event any clarificatory hearing is required, the same may be listed again. Next, subject to that, the matter is reserved for judgment.
Very grateful to your lordships for the kind opportunity, my lord. We have stopped exploration for 30 years because of this issue. I hope your lordships will show a light in national interest.
Very grateful for the patient hearing, Lord. Very, very grateful.
Okay, thank you. It was a very enlightening hearing.
Much obliged.
Grateful, Lords.
Now this bench will continue.
Wait, please, Your Lordship. Lordship, I beg to mention item number 7, Your Lordship. Lordship, yesterday we have submitted adjournment slip, Your Lordship. Lordship, may I adjourn the matter for a 1 week, Your Lordship. Lordship,
You're not
item
getting your
7
voice.
may be-
Please speak loudly.
Item 7 may be adjourned for a 1 week, Your Lordship. Arguing counsel, Mr. A.W. Aman has some personal difficulties, Your Lordship.
We will pass orders when the matter reaches, because we are not adjourning any matters on Tuesdays and Thursdays. When the matter reaches, renew the prayer. Unless advance memo is circulated on Tuesdays and Thursdays,
Yesterday I had submitted it.
yesterday submitted.
Yes, Your Lordship.
Oh, acha, then we'll adjourn it. Then no issue.
Highly
Both
obliged.
sides are represented on the prayer made by learned counsel for the petitioner. Just after 2 weeks.
Okay, highly obliged.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 6. Matter may be possible for the day.
Please, unless there's a advance mention memo, we are not adjourning it. You renew the prayer when the matter. This is item number 7. Item 15, 17. No, 15 to 17. No, you have to read the prayer when the matter reaches. You mentioned advance memos are for item number 7 and 15 to 17. 15 to 17 adjourn 2 weeks. Looks. Yes. It was. Mentioned.
Item 1 with 2 for admission.
Yes.
Yes, ma'am.
Yes. Mr. Sharma,
Yes, ma'am. I'll share with.
Is it Mr. Sharma?
For perusal.
Records are with Mr. Sharma. Where is he?
Ji Sharma. Sure. Ah. Good.
Okay, after some time.
Yes, my lord. Then after some time, my lord, in the meantime, I have to go through the record.
After some time. No, this one, this one. I don't think it's good. Okay. You do open the hands and- Yes, item 3.
May it please my lords.
Yes.
My lord, matter pertains to my detention, my lord.
Yes.
Under Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, my lord.
Yes.
Section 3 of the Act. I am in prison since 27/1/2025, my lord. So
From 27/1.
2025, my lord.
My lordships, Dina through the peer, he highly within my lord. Some report also come to the.
My lord,
Your date of arrest is,
My lord,
your date of arrest is,
27/1/2025 only, my lord. That day only I was arrested, my lord. Since then I am in custody, my lord.
yes, on what ground you are challenging it?
My
Your
lord,
detention?
challenging it on various grounds, my lord. My lord, first of all, my lord, I am not the accused person. The accused person, if my lord has the impugned order, my lord, at page 18, my lord, it is against one Selimuddin alias Farazi. I am Muhammad Salim Farazi, my lord. This is not me, my lord. My lord has page 18, my lords. Annexure 1.
Page?
Page 18, my lords. 18. 1-8. Annexure
Is
1,
it-
my lords.
Is it one of the principles of preventive detention that one has to be an accused for being detained under preventive custody?
My lord, it has to be effectuated against the correct person, my lord. But I am not the said person, my lord. The allegations, my lord, which has been leveled, it is against one Selimuddin alias Farazi, as reflected in the said impugned order. I am Muhammad Selimuddin. Moreover, my lord, I have some other grounds as well. My lord, the copies which were provided to me, the detention order copies, they were not legible, my lord. The language which was told, the language which was alleged against me, my lord. I am not very conversant with English, my lord, but
It's not a good ground. You're just making advantage of your aliases in which you write your name. Your father's name is same, Abdul Quddus Faraji. So whether it is Selimuddin or Selim Farazi, makes no difference.
my lord, there are other grounds as well. My lord would kindly have, my lord, page 172 for a moment of the affidavit in opposition filed by the respondent number 11, my lord. This is one of the major grounds, my lord.
Page?
172, my lord. 170 it starts, my lord. This is the affidavit in opposition filed by the respondent number 11, my lord.
Yes.
May I read, my lord? The petitioner was again arrested on 27/1/2025 in connection with Juria PS case number 26 of 25 under section 61 to 123 of BNS, read with section 21B 25 29 of NDPS Act 1985 and forwarded to judicial custody. My lord, this particular allegation, my lord, this particular case, this is not in the impugned order, my lord. At page 18, and specifically, my lord, at page 21, my lord, all the cases which have been leveled against me, there are plethora of cases, my lord. My lord, this case at page 18 and 21, this case is not there. The grounds on which I have been arrested, the case for in light of which I have been arrested, that is not in the impugned order itself, my lord. Apart from that, my lord, one of the cardinal principles under PIT NDPS Act is that there are judgments of the Supreme Court also which back this, that copies have to be legible, my lord. Legible copies have to be provided to me. My lord, the copy which has been provided to me of my detention, that is only not legible. Pages 141, 142, 143, 144, 145, they are all illegible, my lord.
4, 5, 6
So, my lord, these are some of the primary grounds, my lord. Apart from that, my lords, I had approached the authorities by filing a representation on 13/2/25, which is at Annexure 4, my lord. That was also considered late, my lord. There is a judgment of the Honorable Apex Court. If it pleases my lord.
Please tell us the facts first. Don't, what will you do with the judgment when you are not even saying the date when it was disposed of?
My lord, it was disposed of on.
Tell us the dates.
3/4/25, my lord.
Representation is outdated.
13/2/25, my lord.
The council must start from the day.
Sorry, my lord.
Even day.
Sorry, my lord. Sorry.
Representative of 13/2/25 disposed of on
3/4/25.
where is that?
My lord, Annexure 5, my lord. My lord will have it at page 167, my lord, of the petition.
Very big category schedule, SK schedule. Type copy matter. Spoken number again. This one be 90%. No. He podría sido algo fácil, Press 21 accept to. Yes, again, 21 program. Twenty-one program. File the answer. One problem, real central page 21. Wasn't 21 to the account. What was to the account?
My lord, copy was served, my lord, on. Yes. It is in the affidavit filed by the respondents, my lord. At page 189, my lords will have. 9.
189.
My lord served on 22 January 2025. My lord, here it is written, read over and explained to the detainee about the contents of the detention order in SMEs
30 on the 30th.
and videographed in presence of
30.
witnesses on 30-01. Sorry, my lord.
30.
I copy served and returned on
01.
30-01. Sorry, my 30-01. My lord, grounds for arrest, my lord, page 21, my lord. That's the impugned order.
21.
Page 189, my lord. Same date, my lord, 30-01. My lord, 189. Copy served of, it is reflected there only, man.
Served on 30 January.
30 January.
Yes, ma'am. Served on 30.
30 January 25.
Pardon me?
30 January.
30 January.
2025.
So not on the same day.
Not on the same.
You said same day.
No, my lord. I was arrested on 27/1/25. On 30/01/25, this was served to me. Post arrest.
Yes.
You said on 27/1/2025, you were arrested in connection in another case.
Yes, my lord. Yes, my lord. That is that page, my lord. That is from the affidavit of the respondent 11, page 172, my lord. Would kindly have 172. My lord, this case is not in the impugned order.
It can never be. You see, always make a submission which can be understood by us. The detention order was passed, you said, on 22 January. In that you are thinking that the 27 January arrest should also be mentioned. Either you are brilliant or we don't know anything.
My lord,
On 22nd January, you are supposing that a 27th January order will also be included. That's wonderful.
arrested on 27.
That's why you said you are wonderful.
Do you have anything with regard to Julia Promote Station case number 26 of the first?
My lord, that, my lord, the respondent authorities are saying that we are connected with the case, but we are denying it, my lord.
Deny, don't say that like that.
Yes.
Because they come.
Yes.
But you take away. You were ready there. Yes.
Yes. Yes, my lord.
Don't say in peace.
Yes.
Don't try to say something which is.
My lord, my instruction is
Again arrested on 27/1/2025 in connection with Julia Police Station case number 26 of 2025. Then later on, it says, in the said case, 5 soap cases containing so-and-so were recovered from his house during SARS. The petitioner fled away, but later on 27/1/2025, meaning thereby the case has been registered earlier.
yes.
So that is what the information we need. We could understand from the detention order that there are 4 or 5 cases earlier.
Yes, my lord. This case was not there. That
Not
is my-
there, that's all.
That is my humble submission.
Please tell us in sequence, otherwise we are, it will be very difficult to follow from here and there.
My lord, I was arrested on 27/1/25, my lord. Thereafter, my lord, I was served with a copy of the detention order on 30/01/25, my lord. And I had preferred a representation before the said authorities, respondent authorities, on 13/2/2025, my lord.
Yes,
And the same was considered and rejected.
which is that page, which is that representation is that page?
My lord, it is at page 162, my lord.
One
162 it starts, my lord. 163 contents are there.
Mr. Sharma,
Yes, my lord.
as per your affidavit, where is the reply? How did you dispose of this representation?
While page 167, my lord.
167.
67. It is a part of my record. sir.
To 166. It is 13 February 2025. Yes, as per your reply, when was this representation addressed? Because if you have not responded, then we'll have to take it that it is on 3/4.
You have a record. You have a record.
We have filed affidavit by SP also filed one
But
affidavit.
if the relevant facts are not there,
SP Nagaon filed one affidavit, madam.
no, this will not go by affidavit. On the last occasion, there is an order of the court to produce the records.
Maybe madam sir, Dina sir.
The last order, the relevant records received by Mr. Nath are to be placed on the next date of meeting, the next date of hearing.
Yes, yes, I have received record. Record is here. Yes, yes.
Because Mr. Sharma, if it is not addressed within time and it is repressed on 13/4, there itself is a good ground to set aside the detention order.
It was on 7th October.
By central government, malak 3/4, that is there, but the state malak,
Secretary.
Yes.
Yes.
single record. 29/3.
29.
29/3 state government has rejected the representation, but it is not in the affidavit. Affidavit filed by SP. It is not in the affidavit.
Affidavit by Record is
We
here.
don't even have to go to any other place. If you have not given that, end of the matter. We don't need 10 grounds to set aside a detention order. One count is good enough.
The action number 1 and 2 has not filed, only the SP has filed the affidavit. SP saying only regarding the detention.
That's good. Wonderful.
3, 4, 5 and 6 are filed, my lord. Page 180 onwards.
Otherwise,
Because Mr. Parashar, this is not a regular litigation. It's a question of the detention order. Every respondent must know what to do.
this case deal by the state government, we
It's
central
okay.
government only representation we have disposed of and regarding this person prior to the detention order there are 5 cases pending since 2016, 2020, 2023, and when he was arrested subsequently then another case came out of 2025. Now it was though the detention order up to 22nd January 25. It is served upon him on 30th of January. And as per the Act, he has to be served within 5 days of his detention. So, as per the when it is served, he was arrested in connection with another case, Juria, it is 25 cases, another case. But in respect of this detention order, it was served upon him on 30th of January. On the same day, he has been taken in custody regarding this case. Record maybe.
Record is here. Record is here. Video.
This is the order.
Record is here. And again this, they can't score them. Whatever, I know. No. Everything I said. Yes.
The file by response number 5 to 6.
Affidavit filed by Rasul number 3 to 6
No, still no, so it's no,
is,
it will, no.
this is the report of the advisory board. Page 202.
It will be shown on.
Malad.
Hello,
Affidavit filed by Malad, Rasul number 3 to 6 Malad, in
Lo-
page number 202,
two,
that order has been annexed Malad.
annex minor, annexer D minor.
Annexed. File, affidavit filed by Rasul number 3 to 6 Malad,
3, 4, 5, and 6. Page
page
number
number 202.
2.
202 is the order rejecting the representation dated 29/3/25.
25. Yes.
নহয়
কি এইটো?
নহয় এইটো নহয়
হা, হা?
এইটো বেলেগ বস্তু এইটো সেইটো নহয় এইটো নহয় ছাৰ এইটো
নহয় নেকি?
নহয় এইটো এইটো কনফাৰ্মেশ্যন দিছে খালি
Confirmation.
এইটো নহয় ৰিজেকশ্যনটো পেজ আপোনাৰ ইয়াত আছে 169ত আছে 167 হ'ব
167.
167ত আছে ৰিজেকশ্যন
Central government, no.
তাতে আছে
167 affidavit,
নাই নাই পিটিশ্যন
main petition.
Confirmation and advisory board order.
3-4তে ৰিজেক্ট কৰিছিলে
Advisory board order. Page 1 on the.
এইটো কোনো problem নাই, গাঁৱতে।
Into sir. Advisory, state advisory board, annexure C.
Hmm.
The report of state advisory board and confirmation is at page 202.
This is order of confirmation, but where is the disposal? That the state doesn't say when it was disposed of.
Disposal by the central government at page 167.
No, every authority must do it.
Disposal no होता है, state government को। State government का disposal और होता है। Record solution. तो दिया जाए state.
Advisory board report, then confirmation is page 202.
Yes, हमारे disposal तो होता है, तो दिया है, कोई नहीं। Just.
Sorry, sir, reject annexure 5. Page 167.
State government.
Reject করে দিয়েছে।
Rejected by central government.
Central statute, sir.
Not, but we are seeing state government. Imposition. Some to us.
Paragraph 6. Yes, one. Written over procedure, since of previous. People say, therefore, petitioner was explaining the contents in a language he could inform to. Paragraph 6. In your writ petition, have you stated that which are the languages you know?
My lord, yes, my lord, it is there. I have a categorical averment, my lord. My lords would kindly have paragraph numbers.
We have read paragraph 6 and therefore we are asking you,
Yes, my lord. I know,
what is the language you know?
my lord, I know Assamese, my lord, English, my lord, I have done education.
You have not
class-
said there.
Yes,
You have not said anywhere
yes.
which language you know. You said, you are saying that you petitioner was not explained the contents of the language the petitioner could comprehend.
Yes.
It's very vague.
Detention or.
You may know only Malayalam. You may only know Malayalam.
Yes. Lord, my humble submission is that detention order was in English, my lord. And I am assailing that, my lord, I didn't understand my grounds of detention. Although I had made signatures in English, but that is because of my basic education, my lord, after middle school. That much of English I know. Need to sign. This I didn't understand, my lord. The impugn orders, the grounds on which I was arrested. That is my humble submission.
এই ডিকে বিশ্বাস আর কিছু করিয়াছে একদম
My lord, at page, my lord, 162, my lord.
But from the from the from the record, Manoj, I just want to see. No, in the affidavit, Manoj, they have we have not said. The report was also.
May it please, my lord.
So you've been arraigned as an accused in 5 cases.
Yes.
As part of detention order.
Yes, sir.
Now, were you arrested in the connection with those cases?
Yes, ma'am.
And thereafter,
I was enlarged on bail.
enlarged on bail. So there must be bail conditions.
Yes, ma'am.
When you were enlarged on bail,
Yes, ma'am. My lord, that is not with me right now, my lord. Statement I've made.
Admit question, petition has been enlarged on bail. That's well. Mhm. Where's the person?
yes. Get back.
Oh, father.
Yes.
But that order is not here. Or order. No, that was central government. Central government. It goes on that ground alone. Okay, then hand it over, we close the matter. If you have anything to submit or any case laws you want to submit, both of you, then pass it over, the case laws.
Lodge. Well, in fact, in our affidavit also, we have not said. We have not said. And they have in the record, I have seen one of the central government rejection order they have given. But only that Malad I can verify with them whether if there is any order, that information Malad I'll get and I'll submit. Otherwise, record I'm placing.
No, because unless you pen it down on affidavit, he must know and then the petitioner must know it and then respond to it. Because that can't be permitted.
If it is available on record ballots and somehow it is not given to us, that Malad I can very well. Otherwise, the order has been confirmed. Malad, my respectful submission is Malad. The preventive detention order, Malad, as it is Malad already Malad knows Malad the subjective
So
satisfaction of
see,
the
you
authority.
don't, the state does not say everything. You arrested him on 27th. You don't even say that FIR was registered when.
The case where he was arrested on 27/1/2015. Now, in a case of preventive detention,
Lordship.
who is required to file the affidavit?
The government.
No.
Who reaches the subjective satisfaction?
The
Who reaches?
detaining authority.
Where is his affidavit?
Well, the detaining authority on behalf of the detaining authority, the additional.
He cannot delegate what is his
This
in
is-
mind.
This is nothing, this is not
You-
where it can be
For
delegated.
another person to write that it was in my mind. The satisfaction is of the detaining authority. Now come to page 18. Read first paragraph. A case of preventive detention is to be acted with utmost promptitude. Now read the first paragraph, please, loudly.
Para 18, Malad.
No, page 18.
Page
Lord,
18.
page
The
18.
detention order itself.
Yes, Malad.
The very first paragraph itself.
Whereas a police report and concerned records have been laid before the undersigned by the Inspector General of Police CR, Central Region, Nagaon,
When?
Assam, by this letter number so and so dated 7/10/24,
October.
October.
Read further.
Lodge. And the Superintendent of Police Nagaon by this letter memo number so and so dated 24/9/2024, September.
Now, when the preventive detention order was passed,
It is on 22nd of January 25.
how much after IGP's report?
It is after more than two months, Malad.
3 months almost.
Almost.
No, 7th October, November, December, January, 3.5 months. So is it called utmost promptitude?
Malad, the final letter of
What is the law? Why preventive detention? What is the law?
so that the person
In
is
5 cases, he was arrested.
Malad.
He was enlarged on bail, subject to certain conditions
Lordship.
contained in 437 and 439 of the CRPC. If you violate any condition, right for cancellation of bail is reserved.
Lordship.
5 cases. Then SP submitted report in September. IGP forwarded it in October. And the meaning thereby, it was lying before the detention authority since October. So he showed utmost promptitude of 3.5 months to pass the detention order.
Malad, last communication is of
The object of preventive detention, laws of preventive detention, had itself been perhaps defeated.
but the
This is our tentative.
Lordship.
We are waiting for your response on it.
Lordship.
Because affidavit is silent. Affidavit is silent.
But In
on that.
the date.
And
the
what we are
date-wise
surprised
we
is,
said, Lordship.
and what we are surprised is,
Lord-
you would respond to what my esteemed brother has said,
My lord.
but what surprises us is, you see, for the law and order in the state, perhaps the police is responsible
My
more than the secretaries. Correct?
Lordship.
Now, police highest level IGP says that there's a requirement of keeping him in preventive custody. But your bureaucrats sit over it for 3.5 months. Therefore, if you don't put your house straight and don't have an SOP so that the authorities act in promptitude, the very purpose is lost.
And it is the detaining authority who has to fight the affidavit.
Well, the,
Delegation perhaps is not correct.
well, my respectful submission to this aspect is, my lord, the additional secretary has filed the affidavit, my lord.
He
And
can't-
And
the,
who passed the detention order?
the
he can't-
secretary has passed.
Knowledge cannot be transferred.
And
It has to be personal satisfaction.
What was in his mind cannot be transferred.
well, the
Maybe in the age of AI, in future it is permissive.
But the
Possible.
satisfaction is subjective satisfaction on the basis of materials available before him. And my lord, the preventive detention, as your lordship has indicated, my lord, it is, my lord,
Drastic.
from the conduct of the petitioner, it is shown that my lord, he, after obtaining the bail, again indulges in that, my lord.
Where is
Okay.
that? Did you, he had 5 cases registered.
Yes, my lord.
He
One-
was enlarged on bail in all 5 cases.
My lord, one of
Did
another
you,
legacy,
did you file any application for cancellation of his bail?
cancellation of bail, my lord,
Now you
it's
see
not-
the
it's not
fourth
on-
reason. Fourth reason is that on 27, he was already arrested. You served the detention order on 30.
lordship.
And you have not even recorded satisfaction in the detention order, that there is every likelihood that he will be enlarged on bail. NDPS section 37 is there. You don't even record that satisfaction.
Well, the order was passed on.
That's why you see the date on which the FIR was lodged will be important, that you don't say.
True.
So it was a detention order of 22nd, served on 30. And in the meanwhile, 27th, he was arrested.
Lordship.
You made the statement that he fled away
Lordship.
in that connection, which is not part of the detention order,
No,
right?
it is another.
It was registered later on.
Lordship. It
And
was
you
raised,
say that he fled away. And he was arrested on 27/1. And it was on that the detention order was served. Oh, so he was taken into detention
That's it.
on the basis of 22nd
Detention.
January. On
Lordship.
that day, the satisfaction was surprisingly reached by the detention authority.
My lord,
That is important. The case, the 6th case. 6th case you have mentioned.
5 is there, 6 is the one where he escaped.
here we
Ah.
have mentioned 5 cases.
Yes,
6 is
6th
the
case.
one.
Come to page
172.
172.
In that case, my lord, he was arrested later. 172. Yes, my lord. This we have stated in our affidavit also, in the main
Yes.
affidavit, para 5.
Yes.
Lordship.
So, because I am asking this question, SPC forwarded it in September. IGP forwarded it in October.
October. Lordship. And the
And
final communication from
Detention
the
order is on 22nd,
January.
right?
Lordship.
22nd January 2025.
Right.
This man was arrested in 27th January 2025,
Lordship.
right? But because he fled away in connection with 6th case,
Other case.
right?
Lordship.
So this arrival of satisfaction by the detention authority was on 22nd January, when this case, perhaps FIR, was registered. Meaning thereby, this promptitude got triggered after the FIR was lodged. Maybe this may be a situation, may not be a situation, but it looks like,
Well, the
because
ground,
3.5 months, it appears to be a deep slumber.
that my lord, I can't go beyond the records, but the detention order,
6 months.
but from the detention order and the grounds served on him, Lord, they have considered the materials which were placed by the sponsoring
The first
authority.
line is fatal. First paragraph might be fatal. The law, it is a draconian or drastic law.
Lordship. But the satisfaction has been arrived at by the authority on the basis of the materials available before them, which was placed then, my lord.
SP, it has to be within days. Because that is why the period of serving the detention order and grounds of detention constitutionally laid down. And in the act, as soon as possible, 5 days, subject to giving agents 15 days.
My lord.
So promptitude is the necessity in a case of preventive detention.
Sine qua non.
Lordship.
Yes. Law and order and public order is different. It is a case of public order, not law and order.
That's true. Lordship, Lordship.
These are different. So that waiting period of the detention authority for a period of 3.5 months appears to be inexplicable.
My lord, I would humbly submit, my lord. The materials were before them, and the detention order came on 22nd of January 25. So the order, when it exists, then only Lordship will see, my lord, whether that has been on the basis of the materials or not, my lord. Now,
No, there is something more.
Now the period under
We are asking questions because there is something more. If you come to the order, the prelude to the order of detention, the confirmation of detention,
my lord,
please come to page
202, my lord.
no 195. This is the report by the advisory board,
Yes, my lord.
correct? Now, surprisingly, this is on 11/3. By the time this detainee was arrested in the 6th case,
Lordship.
this advisory board surprisingly did not even inform the competent authority that he was already arrested in connection with the 6th case. That's why we are asking you so many questions. Because the compilation of materials against the petitioner doesn't appear to be updated.
But 6th case, I am also not arguing, because the materials which were, I have to confine, the detention order has to confine with the materials which they have
We
considered.
understand, but you see,
Lordship.
we have to enter into everything which is there on record.
My lord.
There is an order of detention which has been confirmed.
My lord.
That also we'll have to take into consideration. We can't say that we are adjudicating the matter, divorce the confirmation order. We can't say that
Lordship.
unless you permit us to. Unless you waive that.
No, definitely, Lordship.
We'll take a short break and come back.
It is before your Lordship.
Yes, Mr. Nath.
Lordship. Well, as regard the affidavit filed by the additional secretary, my lord, my respectful submission before this honorable court is that, my lord, the respondent number 3, 4, and 5, 3, 4, and 5 are the state authorities, and the additional secretary is also implicated as a respondent number 5 here. So, my lord, on behalf of the respondent 3, 4, and 5, one of the implicated respondent has filed the affidavit not here. And the materials placed before your lordships are on the basis of the records, the relevant records, and from the records, my lord, he has derived the knowledge. So, my lord, that affidavit may be considered for the authority, my lord. The respondent number 5 is the additional chief secretary, and the secretary of the department is 4, and the commissioner secretary of the department is respondent number 3. So for the ground taken by him as regard the service of the documents along with the detention order, my lord, those, my lord, in the record I have placed, those are legible copies, my lord, and he was also read over and he was made to understand, my lord. So for the first paragraph of the detention order, as lordship has rightly pointed out, my lord, my respectful submission would be, my lord, that the detention order came into force when the order was issued, my lord. And in the meantime, after receipt of the records from the sponsoring authority, the last communication was on 26/11/2024, my lord. The records were before the authority, and while examining the matter or taking the decision, my lord, some time they have taken, and that time, my lord, while issuing the order, my lord, that has been taken by the authority. That may not be my lord, considered to be fatal while issuing the order, because the authorities have applied their mind while passing the order. If lordship kindly comes to the grounds at page number 20 in the affidavit, my lord, page 21, my lord, the grounds have been in the grounds, my lord, at page 21 onwards. In detail, my lord, everything has been recorded by the authority, my lord.
Yes.
my lord, the detaining authority on subjective satisfaction has passed the order, and the I'm placing it I'm placing reliance on a decision of the Honorable Apex Court, my lord, and the on the point of subjective satisfaction, my lord. Para 10, 11 and 10 and 11, my lord. This is 2012 2 SCC, page 389, my lord. Para 10, 11 and 22, my lord. If the I'm reading para 10, my lord. If the government detaining authority is able to satisfy that a person either by himself or in association with other members habitually commits or attempts or abets such commission of offence punishable under IPC, the AP Act and the rules subject to satisfying Section 3 of the 1986 Act, he can be detained in terms of the said Act. There is a special act in Andhra Pradesh.
This judgment was passed in context of the AP Gunda Act.
Lordship.
Here you see,
Similar-
please come to this paragraph.
Lordship. This act.
Paragraph 8.
Lordship.
Paragraph 8 says, the definition says, who is a Gunda?
Yes, my lord.
Means a person so and so.
My lord.
Now here you say habitually commits.
Lordship.
So therefore, this is a condition which is available under that he habitually commits, and therefore he can be kept in preventive detention.
Lordship.
So that satisfaction is appears to be somewhat different from the satisfaction which is required in the PIT NDPS Act.
Lordship.
Unless you show that in under PIT NDPS Act also there is similar parameter provision. But there is another judgment which is there on points like this.
But Section 3. But I'll take your lordship to the that act, my lord.
531.
Before that, my lord, kindly allow me to read the para 11 and 22.
Yes, which paragraph you want to read?
Para 11, my lord.
11.
Lordship. The essential concept of preventive detention is that the detention of a person is not to punish him for something he has done, but to prevent him from doing it. Even as early as in 1975, a constitution bench of this court considered the procedure to be followed in view of Article 19 and 21 of the Constitution in Haradhan Saha versus State of West Bengal. A constitution bench of this court, on going through the order of preventive detention under the Maintenance of Internal Security Act 1971, laid down various principles which are as follows. The para 34 has been quoted, my lord, from that decision. Firstly, merely because a detainee is liable to be tried in a criminal court for the commission of a criminal offense or to be proceeded against for preventing him from committing offense dealt with in Chapter 8 of the Code of Criminal Procedure would not by itself debar the government from taking action for his detention under the Act. Second, the fact that the police arrest a person and later on enlarges him on bail and initiates steps to prosecute him under Code of Criminal Procedure and even lodges a first information report may not bar against a district magistrate issuing an order under the preventive detention. Third, where the person concerned is actually in jail custody at the time when the order of detention is passed against him and is not likely to be released to be for a fair length of time, it may be possible to contend that there could be no satisfaction on the part of the detaining authority as to the likelihood of such a person indulging in activities which would jeopardize the security of the state or the public order. Fourth, the mere circumstances that a detention order is passed during the pendency of the prosecution will not vitiate the order. Fifth, the order of detention is precautionary measure. It is based on a reasonable prejudice of the future behavior of a person based on his past conduct in the light of the surrounding circumstances. Well, if Lordship kindly comes to page 18, the detention order, the detaining authority has recorded his satisfaction. Lord. I'll take your Lordship to the provision of section 3 also of that act. But before, if Lordship kindly comes to page 18, the detention order, the first 4 paragraphs are recital. Malad. His satisfaction has been recorded here. Whereas, I'm reading Malad, the 5th para. Whereas, as intimated by the SP Nogao by this later memo number, Lordship, by this later memo number 24/9/2024, that the accused Selimuddin alias Feraji has been found to be a repeated offender under various sections of NDPS Act 1985, and his detention under PIT NDPS Act is imperative to keep him out of business of illicit trafficking in narcotic drugs and psychotropic substances and break the network of drug supply in the district of Nogao. Whereas I so and so Secretary to the Government of Assam Home and Political Department and Detaining Authority under PWPS Act on perusal of the office records and recommendation of the Inspector General of Police CR Nogao and the SP Nogao satisfies that Salim Uddin alias Feraji, son of so and so, has been acting in a manner prejudicial to the provisions under the NDPS Act 1985 is by continuously indulging in illicit trade in narcotic drugs even after his arrest several times and thereafter in exercise of power and therefore in exercise of powers conferred under section 3(1) of the Prevention of Illicit Traffic in Narcotics, Drugs and Psychotropic Substances Act 1988, to hereby issue this order detaining the accused Salim Uddin alias Feraji as be detained under the Preventive So and So Act of 1988 until further order. Record, sir.
Mr. Nath will find it very difficult to apply this judgment. Because the judgment must be read in the circumstances of the facts under which it was decided. You please come to this act. You have the PIT NDPS Act.
Yes, Malad, I have.
You see the definition, it doesn't have habitual offender.
But I would like
This
to.
Gundas Act we showed you, there is a reference to a
Malad, on the
habitual offender.
on the principle of preventive detention, to what extent the satisfaction of the authority Lordship will see, Malad? If to what extent the satisfaction will record, that is what, Malad, my endeavor is, Malad. Kindly see, Malad, section 3 of the Act. There also, Malad, satisfaction has been
No power, there is no difficulty in understanding that they have the power.
Malad, para 11 has said that it is to prevent them from indulging in future activities, Malad.
That's why I say.
Lordship. So the
It must
person
be read within the meaning of this definition of Gundas Act, where it says habitual offenders. Because if one is a habitual offender, you prevent him to do habitual offender to again commit that offense.
Lordship.
But this same is not there in this act. Even if you commit repetitive offense of the NDPS, your act doesn't say it is a habitual offender.
Ultimately, the law of detention is to protect the public interest at large. and by passing the detention order, because the very object of the act is that, my lord.
SP has explained the reason. Rationale for issuing detention order.
Lord,
Mention about the 5 cases.
Lord,
Then he says, all these helped him to get bails after arrest. Right? To get bails after arrest. Bail order is passed by a court. It is a judicial order. Right? Then he says, evade arrest for a long time. What is this? Same line. All these helped him to get bails after arrest. Orders passed by judicial forum, judicial order,
Lord.
and evade arrest for a long time. If he has got bails in all these cases, why is the question of evading arrest? I find difficult to understand. If he has been granted bail by courts, then how he can evade arrest? All 5 cases. This is the report. Taking advantage of certain loopholes in the existing legal system.
Page 1 question.
Citation.
55 or 45 SCC. 55 of entry SCC is to
Very different. Very different, that's. Not different. Mr. Nath, from the record, do you have the PIT and DPX Act?
I have,
Section 3, subsection 2.
Lordship. Two, my lord, definitions.
No, subsection 2
Sorry,
of
sorry,
section
sorry,
3.
sorry. Two, yes, my lord.
Yes. Where is the report?
Where any order of detention is made by a state government or any officer empowered by the state government, the state government within 10 days towards the central government sent a report. This report we have sent, my lord.
Mark it.
Report to professional.
It is a. For cancellation, the way instead of facing him under the office. So 30 seconds of condition to hold. So he cannot insert it. So he is correct. It's not helping your document, any your providers. That relating to it. The third thing is that. They also.
Well, the information of the detention order, it is in the detention order itself, my lord, it is marked to the Deputy Secretary, Pit and DPS of the Finance Department of the
No,
government.
it is a report, not the order. See the language.
Lordship.
When any order of detention is made by the state government or by any officer empowered by a state government, the state government shall within 10 days forward to the central government a report. Detention order is different and report is different.
Lordship.
In respect of the order.
My lord.
Where is that? Strict law requires strict adherence.
That's true. That's true. Well, some difficulty while asking for the record I have faced, because nowadays, because of e-office, some orders and notes are not available in hard copies. Those are in online, matlab, those are there. But these two informations, matlab, number one is, matlab, I have asked for the consideration of the representation, and second is whether this has been communicated to them or not. These two informations I'll apprise you on the code. Otherwise, in the record which they have given, it is not there. Except the detention order, marking of the detention order to the central government. It is not there.
If we
Wait, please, man.
1 minute.
So you have to agree to the statement.
What question?
Sir, page 174. Reflection to 3 4 lyrics.
No, I don't know. I don't know. I don't know. I don't know.
In almost,
3-2.
Mr. Nath, in
Mal.
almost exact same situation. Okay. 3 judgments. In view of the above object of the preventive detention, it becomes very imperative on the part of the detaining authority as well as the executing authorities to remain vigilant and keep their eyes skinned, but not to turn a blind eye in passing the detention order at the earliest from the date of the proposal and executing the detention order, because any indifferent attitude on the part of the detaining authority would defeat the very purpose of the preventive detention and turn the detention order as a dead letter. Here is the same situation. SP forwarded 5 months back. IGP forwarded a report to the detaining authority 1 month thereafter. Then detaining authority sat on it about 3-4 months. The exact situation, the very first paragraph, that is why I have pointed out the law is like that. If a person is to be detained, then every authority has to act with
Promptness.
right.
Not. Well,
So ultimately it has observed same situation.
the after issuance of the order, malad, it has been served within time and other processes have been followed. But the sponsoring authorities report and the consideration, that malad, I have to go by the record only.
Because there is no explanation.
That's true.
So that has been
True.
the matter which was considered.
Not
Right. That is why I have put the question.
Malad. Lordship has indicated the may I note down the
Sushant Kumar Boni,
Lordship.
you Lalit, Ravinder Bhatt, and Justice Padiwala
Lordship.
versus State of Tripura. PIT and DPS Act,
Malad.
nothing else.
Malad.
Exact same situation. 4 number of cases. There he got bail. Then same kind of proposal, same kind of delay on the part of the IGP, then detaining authority. Delay in passing the order of detention from the date of proposal thereby snapping the live and proximate link between the prejudicial activities and the purpose of detention, and the failure on the part of the detaining authority in explaining such delay in any manner. Goes. Because you ought to have explained. That is a loss, subject to your explanation. Hmm. Anything?
But in fact, in our affidavit to that effect, my lord, the delay in passing the order, we have not stated, because it is also not a pleaded case of the petitioner.
Not required.
That is the basis on almost all the judgments in preventive detention cases. Even in a given case, 7 days delay in the submission of representation were held to be fatal.
Got you.
Now you failed to produce the order whereby the representation has been disposed of. That is not there in your record. I have checked.
Got you.
That is not there. You are silent in your affidavit on that aspect. Delay of these 3.5 months, not explained. Then law is that bail condition violation. An order of preventive detention is not a substitute for bail condition violation. 437 CRPC says that if a bail is to be granted, the conditions of bail are to be incorporated. That if he indulges in similar kind of activities, then this, bail is to be liable to be violated. No bail applications for cancellation. No applications for cancellation of bail was moved.
We reserve the judgment.
Got you.
And Mr. Mahanta, we are sorry, Sharma, we are sorry, we have not granted desired assistance to us. Merely by starting with Supreme Court cases doesn't help you unless you tell the facts. In this case, we don't find any assistance from you. Heard. Mr. P.R. Sharma, non-counsel for the petitioner, as well as Mr. D. Nath, a senior government advocate, and Mr. K. Parashar, CGC appearing for the Union of India. Next, the submissions by the respective appearing counsel is concluded. Mr. D. Nath, a senior government advocate, has handed over the photocopy of relevant records. This photocopy.
Original.
Original. Okay.
Yes.
The record, the relevant records. The same is retained by the court. Judgment reserved. You are relying on any citations?
Yes, sir.
Give a list, make a list and give it to the court master.
Lot. I have already handed over one, Malad.
Yes, you have
One
given
I
this
have given, and-
G
and-
radia.
idea.
Yes, but another is 2017, one SCC 757.
Give the list.
I'll give. I'll give.
Give a list.
Yes.
And there are several judgments of the Supreme Court which says that the affidavit is required to be given by the detaining authority. Or if he does not give, there must be a sufficient explanation why he has not filed an affidavit. So perhaps it would be better if the state has a SOP to how to deal with these matters.
Then if he has been explained the contents of the documents the detainee was handed over, then that translated copies of those are to be furnished. Constitution means judgment.
Because somewhere in your record, it says that he is class 10 passed.
SP's report says class 10.
Well, the record shows that he has been explained in Assamese and he has been made to understand.
No, the basic fundamental things you have not written. You have not said that what is his mother tongue. That's why I asked him at at random. I asked him that whether you know Malayalam. He said yes. Incidentally, what has happened was that when he was arrested, your arrest memo says that he came from Kerala. I said in inadvertence, it's not knowing that how he had come and he was arrested. But when we are reading these records, on 27th, the police report says that he came from Kerala and he was arrested. So Malayalam was just a out of the cuff remark, and it because unless you say that, you see, a person may come and say that yes, I know Assamese, but my mother tongue is, say, Gujarati. Then the question will come as that he knows, but whether he can read and understand. So the satisfaction, my esteemed brother has rightly said, he was just surprising me. And in fact, this is an aspect I was not aware, but comparing the NSA brochure made by the state of Nagaland, they are far better than what is here in Assam. And my esteemed brother has said that not only that, they record the satisfaction very carefully about the language. That he is aware of the language, he can read and write that language, and therefore submitted in that language.
In Nagaland cases, the SP's report, IGP's report, they are self-sufficient. Everything is recorded there. But I find this report deficient.
And there's something more. The lawyers in Nagaland would be more conversant with the detention laws.
True.
And
Cases are very.
PIT NDPS case,
Lot of
cases are galore. We have dealt with many cases.
Lot of cases are there.
Unlike in Assam.
Lot of people see, when we have said that he has put his signature in English and he was made to understand everything. Lot of people also see what prejudice he has said, what prejudice.
In NSS, this detention orders prejudice is not the issue. You see, I will tell you, if you follow, let us say you open up a news at random and then start hearing news in even a foreign language or a language in Punjabi or Marathi, you will be following 80% of it. irrespective of the language, you will be following it. That doesn't mean that you know that language. You are following it because of your intuition. You are just understanding it by the virtue of the language used, the expressions made, and therefore you are following it. There's a difference between knowing
Translated
and understanding.
copies are not our dictum, it is the dictum of the Supreme Court.
You are reiterating it.
Not.
Make the lordship. Lordship, item 19 is a part third matter. Maybe this bench will not take up this matter, lordship.
Which one?
Item 19, lordship. Part third hearing matter, lordship. I have approached registry, lordship, next week's Madam Honorable Mrs. Justice Susmita Madam is not available, lordship.
This is partnered with Honorable Justice.
Yes.
Susmita Kaur.
Day before yesterday.
Day before yesterday.
Yes.
Lordship, may I pray to list this matter tomorrow, lordship? Only tomorrow is the date. Justice.
We'll see. She's okay. We'll see. Let me check up. We are not passing and we are not saying anything. Let us
Okay.
check it out.
Lordship,
Hmm.
I have approached registry. They said that next week justice is not available.
Okay. I'm really not aware.
Lordship,
I'll consult my court counsel and then
lordship, deeply
we can
appreciate.
inquire tomorrow morning.
Lordship,
Hmm.
God bless.
Daily list item 4 for admission.
Mr. Sharma, you have the records with you? Yeah, can you pass it on? Great.
Detention. 18/2/2025, lordship. And grounds were also served same day, lordship. Lordship will find impugn order page 15, lordship, of the writ petition. Annexed A, lordship. Same day, lordship, that is served, lordship. 4 cases are mentioned, Lordship, out of which one is IPC offense, Lordship.
These cases are at the stage of trial,
Trial, Lordship.
and you are facing the trial.
I am facing the trial, Lordship. And enlarged on bail in the year 2023 itself, Lordship, in all 4 cases, Lordship.
Mr. Sharma, circumstance in the present case is also similar to the one, the last case. You have anything to say?
My lord, so far time period is concerned, that's true, my lord. I have
No,
heard.
and again, this, in this case, is again the same thing.
Same
The state authorities, they have not stated anywhere about passing of the disposing of the representation.
Right.
There's nothing on record.
that
In fact, all the
representation,
records produced by you also does not contain that.
representation has been disposed of.
It is stated in the affidavit.
My-
Is it available?
Lordship, I have
Yes.
annexed, Lordship, subsequently disposed of, Lordship. I have annexed in my
The
affidavit in reply.
representation was disposed of the representation dated 13/3/25 has been disposed of on 6/6/25.
Page 69, Lordship.
69.
Lordship, affidavit in reply, Lordship.
So
That was disposed of after confirmation order, Lordship.
after confirmation,
Lordship. Page 69.
But the order, final order of the, my lord, advisory board is prior to that. On perusal of that, my lord, advisory board's order, that representation has been disposed of. It was passed on 8/5/2024. The grounds of the petitioner is two, my lord. One is, my lord, regarding disposal of representation. And another is language, my lord, explanation of language. That is all false, falsely, my lord, stated. It was, my lord, on videography, explained in the Assamese language. The footage of the videography is also with me, my lord, if your lordship want to praise it, my lord, praise. That is the main ground. He stated, my lord, it was stated in English, not in Assamese. Assamese is known to him. My lord, conversation is, I have seen, my lord, the videography is provided to me in pen drive. Totally false statement made, my lord.
I just telling my brother, my son was then very small, about 6, 7 years, 8 years of age. He used to look a lot of Cartoon Network cartoons. There used to come a Japanese cartoon serial, and he could sing the Japanese song. He does not know Japanese.
That's happened, my lord. But in the present case, it will not
no,
apply as per my humble
No, your
submission, my lord,
satisfaction is
because
no, your
if your lordship see
no,
the
no.
conversation,
no,
he knows
your
the Assamese, he speak Assamese.
no, that's okay. But you see, you don't record this, record the circumstances. You don't record that he knows Assamese. You have translated and explained.
My lord,
This videographed.
my lord.
But your satisfaction is not recorded that, well, he knows Assamese and therefore it was explained in Assamese. His mother tongue is Assamese.
My lord, lordship may see there is a, my lord, the note of the jailer,
Which page?
my lord, on the record.
In the record.
Right.
So he says explained in Assamese.
Yes.
That's okay. We're not finding fault with that.
And since it is, my lord, under videography, my lord, I don't think, my lord, another evidence is required because everything was done under the videography.
However, the petitioner very cleverly, my lord, made a false statement that was not in understandable language, my lord. Clearly, my lord, stated in paragraph.
No, somewhere in the record, we find that this man, he puts his thumb impression. You have taken his thumb impression.
And he says in his report, education and qualification not known.
My lord. But it was, my lord, read up, my lord, in the pedagraphy.
No, we told you we are not finding fault with that.
My lord.
Question is that whether satisfaction is recorded. You see, in this courtroom, you find me reading Assamese. Assamese is not my mother tongue, but I still read in Assamese. And your affidavit is signed by an officer, his name is given there. My esteemed brother asked me whether I know the meaning. I did not know the meaning, so he told me the meaning. So the conversation in the language, the understanding of the language, deliberation in the language, still makes me a novice when it comes to the meaning of a particular word. I can't know the meaning of the word unless I see a dictionary. There are several conversations which goes on with several colloquial proverbs. They have a different meaning. It may look different, but they have a different meaning. Those I may not be able to follow.
But in the present case, my lord, what understood, my lord, by seeing the videography, my lord, he is well, he did not say anything that I do not know. I fail to understand. Nothing was there, my lord. He should have, my lord, react, my lord, if, my lord, he is not understand the language in Assamese. Everything was, my lord, stated in orally. If he is not a literate person, in the said circumstances also, my lord, it was explained such a way so that, my lord, he understand the contents of the order. And so far satisfaction is concerned, his detention is very much necessary, my lord, since, my lord, the Nagaon is a hub of, my lord, that is narcotic drugs trafficking. That is reflected in the advisory board's hearing also, my lord, which I have annexed with the affidavit. It is in the record also. Lordship, If, my lord, the observation made by the advisory board at page 59, while taking personal hearing of the detainee, my lord, that one paragraph, my lord, in course of page 59, my lord, in course of personal hearing, the detainee stated that he is about 24 years and married. His family consists of wife and 2 minor sons. The detainee further stated that he has been facing trial in 3 drugs-related cases where, after availing the bail, he regularly appeared. He stated that one, Lalu Mia was his partner in drugs trafficking activities. He stated that he has been under detention in connection with the instant case since 26 to 2025. The detainee stated that he received a detention order on 26 to 2025, along with legible copy of all the relevant documents. While delivering the detention order, the jailer, Central Jail Nagaon, read over and explained the contents of the detention order and the grounds of detention in Assamese language, a language known to him, under videography in presence of some witnesses.
Mr. Sharma, these things are daily experience. You go to a trial court, your evidence is recorded of your witness,
Hello.
and then the magistrate or the judge writes ROAC. But in my experience, I have never seen that. Subject to however your experience may be different, but
I don't
in
answer,
a
sir.
trial court, my limited experience, no. There was only one incident where the senior lawyer became very cantankerous and then he wanted to have a fight with the court and therefore had it. But that is the only occasion I have seen the read over and explained.
But so far nowadays, my lord, since everything is done under videography and witnesses are also present, nowadays, my lord, so this type of cases, there is merely a scope for manipulation. This detention is, my lord, very much necessary to break the network, my lord. Since your lordship, my lord, seen, my lord, nowadays, my lord, trafficking or NDPS so far in some areas of Nagaon district. And so far the earlier case also, my lord, perhaps, my lord, of same area, same district. Since
in spite of section 37 of the NDPS Act, how judicial order has been passed for bail. If really that was vulnerable, you had an option to file an appeal also. And if he has violated the conditions of bail, in all the 4 cases, you had the opportunity to seek cancellation of the bail. If the judicial order granting bail is vulnerable, he could have appealed, challenged in the higher forum that this order is bad. And secondly, if he has violated in the meantime, he is facing the trial in all the 4 cases. That is your admission.
that's true, my lord.
And
All the
Mr.
cases,
Sharma,
my
I have a
lord,
different way to explain it to
citizens
you.
are
I will explain it to you
phase of
differently.
trial.
Same thing I'll explain to you differently. If you transpose yourself from here to here, and then think of a situation where you are moving a bail for a drug peddler, and you get a bail. Now, what would be your comment that somebody has managed to get a bail? Because now manage is 2 things. Number 1, management. This is the management of the lawyer with the judge. Is it the management of the lawyer to get a bail in an unscrupulous manner, or you want to have an imputation against the judge about the integrity?
That is the language of the SP.
Managed to get, if somebody tells a lawyer that you managed to get an order, that means the integrity is doubtful
No, that is not.
of the lawyer also.
That's, my lord, incorrect statement.
No, I'm trying to understand. This is a language which is normally used. There may be a case where somebody, some lawyer was arguing before the court
Everywhere, my
while
lord.
going out.
Everywhere, my lord, we have seen, my lord, because of investigating officer, bails are getting.
No, not that,
accused.
because we are accustomed to it. People argue in the lawyers argue in the court, and while going out, they will say, "Yeah, this judge has not understood anything.
Lack of knowledge and something, my lord.
Judge does not know anything. He asked me this basic question, he does not know anything." We are accustomed to hear that.
He worked there. He has developed, tried, and tested network of drug peddlers, information network movement of police. That is, police all for information network he knows. Legal protection channel through layers. All these help him to get bails after arrest and evade arrest for a long time. In current prevailing judicial system, it will be difficult to keep him in jail for more than 10-15 days. If it happens so, not only he will be emboldened, but it will further act as a moral booster for other drug suppliers and moral buster for police. So, preventively detain him. This is the language.
I understood, my lord. This type of language, my lord,
This
should
is
not
the
have been
SP
used.
version.
Should not have used. These are the problem with all of us.
He does not have the minimum tactics.
That's true, my lord.
Education
It is correct.
qualification.
It is correct, my lord.
He says nothing. Educational qualification not known.
Whether literate or illiterate or
Not known.
not known is cannot be, my lord.
Cannot be.
Cannot.
No.
Full name, not known. Present address. Is particular. All this, he has got bail. Just because he has got bail. Can it be a ground for preventive? And what Progness? Same thing. SP report September, IGP report October, and your returning authority has so.
Additionally,
Progness
here, my
3.5
lord,
months.
here, my lord, December, they asked for additional information that has.
I have seen them.
December and that was
Yes.
February.
He has seen nothing in there. I have seen it. I have read. And you go by basically media report. Yeah. Media report. Newspaper cuttings.
So her activities of the detaining, that is
I'm
undoubted.
on that.
That is undoubted, my lord.
All these materials are yours. If you fail on that front, so you start taking action on the other. Preventive detention is very drastic. Judicial custody. Yes, the accused got bail on the airport protection. Isn't that true? Was found indulging during his bail period, he is still suspected. It's nothing illegal. That is a good job for cancellation of bail. It's in the law laid down. I am not speaking on my own behalf. The law laid down. Go ahead. Oh. I
That's true.
I come back.
Lordship, I have two points, Lordship. I have stated in paragraph 6, Lordship, I am already on bail without violating any bail condition, Lordship. Paragraph 6 of my petition, Lordship. And I'm facing trial. Out of these 4 cases, 3 is under NDPS, 1 is IPC offense, Lordship. And another is, Lordship, at that moment, Lordship, the impugned confirmation order was passed, Lordship, on 11/5 without assigning any reason, Lordship, independent reason, Lordship. And at that moment, Lordship, my representation was pending before the detaining authority, Lordship. So the advisory board rejected the same. Lordship, advisory board rejected on, Lordship, 8/5/2025 and detaining authority on 6/6/25, Lordship. Lordship, advisory board rejected, Lordship, on 8/5.
No, advisory board makes recommendation. They don't reject.
We also mentioned, Lordship.
Okay, it's mentioned there.
Lordship
Okay.
mentioned, Lordship.
Advisory board on
8/5/2025, Lordship.
And representation,
Representation 13/3/2025, Lordship.
13/3/2024.
Lordship. Lordship. And confirmation order 11/5/25, Lordship.
So what do you say?
And
What is the point?
point is that the detaining authority, Lordship, rejected the representation on 6/6/2025, Lordship.
13/3/2025 is what?
Representation, Lordship.
Date of representation.
Date of representation.
Is there any illegality?
I took the ground, Lordship.
Ground? No.
Lordship.
One can make 100 grounds,
Lordship.
but what is the soundness of that ground?
Lordship, confirmation order also only relies on the advisory board, Lordship.
Huh?
Confirmation order, impugned confirmation order also rely on the report of the advisory board, Lordship. And this relying on these 4 cases only, Lordship. There is no case registered subsequent to that. He was enlarged on bail in 2000.
So what is wrong? Confirmation order relying
Lordship.
advisory board's
Lordship,
view. What is wrong?
Lordship, in 2023 itself, he was enlarged on bail in 4 cases, Lordship.
Yes.
He was facing a trial, Lordship. Subsequently, no case is registered against him, Lordship. Mainly they have allegation, Lordship, but no case is registered.
What are the cases?
Lordship.
Let us see.
Lordship.
2021, 22.
no, but the incriminating material is that you tried to escape, you were shot, and even after that you were engaged in another case and you were caught.
All cases are prior to that, Lordship, on which he got the bail, Lordship. These are the allegations.
You were shot in the 3rd case.
Lordship.
After that, there is the 4th case again. That means even after your apprehension, after apprehending you on being shot, still you carried out this. That means you are incorrigible. Why you should not be remained in this preventive detention?
Subsequent to that, these all are of 2023, Lordship. After bail, Lordship is facing trial and no case registered, Lordship. Though they
That's
made
okay, but your conduct
Lordship.
in the 3rd case, when you were arrested, you tried to escape, you were shot. In the 4th case again.
But they never move any application for cancellation. Page 33 of my affidavit, Lordship, I have.
से first. Page 54. 3523. That is 48 or was 14? 48. Complete hours bears, peddler was selling which quantity? 14.8. Rupoya PS case number?
Rupoya.
14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 14. 394. Page 56. Yes, sir. People to replace the above. Mr. Sharma, we not been able to follow something. You come to page 54. There's some gap somewhere. Come to page 54.
Yes.
This says that you resorted, after arresting him, he started to run and he resorted to 2 rounds of firing.
Yes.
Correct?
Yes,
This refers to Rupai Hat PS case number 218 of 2023.
my lord.
Then you say on 14/8, the information was received that he was selling drugs.
My lord.
And next page 55, this is the quantity of drugs seized.
My lord.
Then 56,
Page 56.
56.
My lord.
Now this is Rupai Hat case number 394 of 2023. Para 1,
Yes,
right?
my lord.
Now next
361.
next para, page 56, the same para, the next para. From the 4 cases, now you referred in the order, you only refer to 4 cases, 361. You don't refer to 394.
It is CS number, Lordship.
Yes, PS case number.
CS number, Lordship. Charge sheet
Oh,
number.
charge sheet
CS
number.
number, sir, sheet number.
Might be,
390.
Lordship.
Okay,
Might be, Lordship.
361. Okay, okay.
No, story is different. Story is completely different. 14/2023, this specific information. So they proceeded. Then contraband was recovered from one Bablu Mondal in the student show. Recovered 4 showcases from the apprehended person Bablu Mondal. And mobile, all these things were recovered. They have on the basis of information, they proceeded to the house of one Roshanara Begum and apprehended her. From her house, again 2.4 gram was recovered. Then, during the course of investigation, apprehended person revealed the names of the below named persons. Again, you arrested this thing on the basis of information. So no recovery from his person
Then
or from his house.
There is a network.
no. Then page 55 is false. Then page 55 is false. In 55, you say, fourth line, complainant along with PS staff proceeded to so-and-so Tiniali under avoided PS and apprehended you from the place of occurrence and one drug peddler, namely so-and-so, Bablu Mandal. Concerned and recovered 4 number of soap cases suspected to be so-and-so gram and without soap gram from your possession.
Totally wrong.
This is false. You are manufacturing cases.
The price is only difference.
That means none of them applied their mind. Even your advisory board, even your detaining authority.
From you see this one, this page. This is the FIR. Public statements of them, this person did it, from his person house. Everything was That statement. More variance. It is possible. Or if you need to validation. Pablo Monroe of father. I don't know what. Fine. Very good. He's really okay. Yes.
54.
My lord, last line, during the course of investigation, apprehended person revealed the names of the below noted accused person who were involved along with them in the above referred, and since the day of occurrence, the below noted accused person had been absconding from police arrest, and as per engaged source information, they are trapped and apprehended.
No, we are not on that. We are in NDPS case. You know the rigors of section 42 of the manner in which possession drugs is to be seized from the possession of the accused person. So if that is not there and it comes to your affidavit,
However, my lord, all the
please tell
premises-
us.
My lord, search it.
Now, please tell us, how do you proceed against the person who has sworn the affidavit for for swearing a false affidavit?
Affidavit in opposition. Oh, no.
Advisory vote.
This is the report of the advisory report.
No, the report of procedure code, na? You have to vegetation plan.
Kind of coding is a Yes, but routine and when but each weekly is one. You know, absolutely.
9. Grounds of detention. Grounds of detention. This is a part of ground of decision. Which page is the ground of detention?
Lordship, page 18, Lordship,
18.
18, 1.
That you.
Hmm.
Yes, Mr. Sharma.
My lord,
Request. Page 21.
21.
You have read the FIR?
Yes, my lord.
Page 20, it starts from page 20. para 6.
On 14/8/23.
Yes, yes, please.
We have to see, my lord, who is the Rosanara Begum. Maybe, my lord, he is related to.
First line.
My,
Proceeded to site area, under police station.
my lord,
Apprehended you from the PO.
my lord.
Does it go together with the FIR? That is what I am pointing. So this detaining authority, by preparing the grounds of detention, did not represent the true state of affairs. Because had it been so, he would have been arrested there and there. But he was arrested in November. And he was not there. Only Babdu Mandal was there.
He was
FIR
absconding.
was not there.
As far as he was absconding, my lord.
No. And this is different. Your position. From your position.
He can't be absconding unless you allow him to.
My lord, Rosanara Begum maybe.
Don't bring Rosanara.
You see, unless the police at that time allows him to abscond, he will not be absconded because it was seized from his position.
Maybe this, my lord, related to one case. My lord, there are three.
We don't know. It's for you to satisfy us. Because we are satisfied that there is no case at all. You are manufacturing cases just to put him under bars.
That's not correct, my lord, because, my lord, we have to, my lord, prevent the drug, my lord, trafficking. That is the main intention behind the detention, my lord.
We don't know.
Only that's the problem. Otherwise, my lord, so far these people are concerned, there's no need to detain. And so far,
You have the available and regular process because, sir, Sharma, this is preventive. Not regular investigation, arrest, bail. It is a drastic power at the hands. One government failed.
reason may be, my lord, failure of our machinery, but so far the intention behind,
No,
my lord,
intention has to be there. Otherwise, why will someone tweak something which is not there? How will somebody manufacture?
so far,
Unless
regarding cancellation of bail, it may take some.
no, not that, not that. You have read the FIR and you have read the report days before the advisory board. Now, please tell me what is the interest of that someone to tweak the facts?
either deliberate or non-deliberate. If deliberate, this is malafide. If non-deliberate, non-application of mind.
There are some, my lord, I have seen, my lord, due to some, my lord, language
No, but
used, my lord.
no, but take a very, very thoughtful decision. You take 2 minutes rest and then tell us. Once we put this in the order, you know what will happen to the trial. Now, what do you want from us? We just now give you an example. You managed to get an order.
My
What
lord,
do you say? What do you say that we should do?
well, that aspect, my lord, it is different, different from the case, my lord. It is unfortunate, my lord. It is, I say unfortunate, my lord. That language should not be used.
No, not on that. We are now asking you.
But so far, my lord, is grounds of detention and these things are concerned. May I pray, my lord, a little accommodation for any other day, my lord.
No, no. After spending time.
My lord, only to satisfy this aspect.
No,
my lord.
it's a record which says that's why we called for the record.
Yes, my lord, record is
We
here.
don't need anything else. Because if you see, it will be a bad sign for the democracy if police starts manufacturing cases. Today it is X, tomorrow it may be Y. Day after tomorrow it may be A.
Here are, my lord, no, my lord, issue regarding, my lord, manufacturing.
Because question of Article 22 is already there.
My lord, some, my lord,
Non-application of mind.
that may be, my lord.
Then goes,
Then also it goes.
That may to some extent, my lord.
if not A, then B.
Because option B will not come. As my brother has proposed, I am not objecting to it. But option B will not come because the police people are trained to look at the FIR and reduce it into the GD entry. It can't say that he did not, he failed to appreciate that in the FIR, the drugs were not seized from him, and in the GD entry, he will make an entry that it was seized from him. Then he's unfit to be a police officer.
No, no.
Detaining authority.
Detaining authority, no, no.
What does the Superintendent of Police say?
Record.
Record it here.
Oh, yeah. It was the reporter said.
Is it correct? SP said correctly. It is the detaining authority while preparing the grounds of detention.
My lord, lordship may see
Made this addition. 1 minute, out of class.
serial number 4,
Out of
grounds of
out of
detention.
class, out of class. 14 apprehended, recovered, found a possession, Pablo Mondal.
I don't.
Hmm.
इसी के साथ
While referring to that case, fourth case, SP nowhere mentioned regarding the manner of involvement in the fourth case. SP while submitting the proposal, right? You were charged with it, but your involvement in that case was not mentioned by the SP.
you're an accused. Detainee.
Huh. He is an accused.
Detainee.
Detainee.
Hmm.
Meanwhile, sorry, detainee. Sorry, detainee. Detainee of 20 now. Covered up with it.
So for
Whoever has prepared
other case,
the grounds of detention,
my lord,
it is always to be treated as prepared by the detaining authority.
The underlying message we want to give is that some Bada Babu had prepared it and he has signed it.
That too, without showing any promptness. To sign for you? To sign.
so for other cases are concerned, my lord, that is serial number grounds of detention 3 and 4.
Refer to judgment. আৰু additional যিকেইটা আছে মেলাবাইটিং গ্ৰুপৰ নন এপ্লিকেশ্যনৰ মাহিনী আৰু এইটো ট্ৰিটমেণ্ট ঠিক পাৱাৰ এক্সাৰচাইজ উইথআউট preventive. Article 22 violation. However, Article 21 put go together. We should go to here first. Think you want to execution. Execution. It will this makes sense. Basically, we use a plan. No, local control.
Let's say apart from my lord, paragraph number 6, paragraph number 3, 4, and 5. So far other cases are concerned. This clearly reveal my lord his involvement. Page 18 and 19 of the application.
You don't and then after you play this going one key walking. You don't mind, I think seriously. Promise নাই. Promise নাই. Suddenly মঙ্গল অফিসের আইরে শুরু করিলেন।
So for my lord, statement and environment made in the petition, my lord, so for grounds of my lord, challenge is concerned, my lord, language 1, and 2 is my lord, representation, and thirdly, we have taken the plea that he is involved in the trafficking cases in the affidavit, categorically saying that he is involved subsequent to his, my lord, release on bail. My lord, there is no, my lord, reply against all this.
It is only because he is involved in the drug trafficking that we are giving you an opportunity of satisfying us. You see, in a preventive detention order, we don't need the 10 grounds to set the order aside. It can be one small ground also. So therefore, we are hearing you just trying to understand whether there was any material which is worthwhile to keep him in the preventive detention. You don't even record a satisfaction that regarding section 37 of the NDPS Act. You don't even record a satisfaction that there's a whether they under in view of section 37 there's a likelihood of getting bail. But the officer goes and he thinks that, well, he's been managing to get bail, and he not only alleges with that allegation, he does not even give what you call, he does not even cast a stain only on the judiciary. He also casts what you call questionable, doubtful the integrity of lawyers. He said that there's a network of lawyers and all. I would have understood if he says lawyer A is the culprit who is doing it. But when you say, when you accuse an entire community, all lawyers are bad,
I understood.
then maybe perhaps even you are affected.
That's true.
If one says that, well, there are two lawyers who are doing it, I understand. He's pinpointing two. But when he accuses a community,
In case of a specific case against any personal
the-
individual, that is
otherwise,
different thing, my lord.
otherwise the correct language is that he is racially profiling. He's saying that lawyers are bad. He's profiling people just because of their profession. Okay, heard Mr. M.K. Hussain, learned counsel for the petitioner, as well as Mr. D.K. Sharma, learned additional senior government advocate, appearing for the state, and Mr. J. Kalita. K. Kalita, learned counsel appearing on behalf of Mr. K. Palasha, learned at CEC. Arguments are concluded, order reserved.
Obliged.
Order, records.
Oh, sir.
Record is originally.
Before that, the learned additional senior government advocate has produced the original record, which is retained on record.
Obliged.
Item 5.
So this is tender matter. My lord, the lordship will see the tender, my lord, at page 45. Now, this is for protection of Majuli Island from flood and erosion of river Brahmaputra. My lord, page 45, my lord. If eligibility criteria, your lordship will see, my lord. Item number 2,
45.
45.
Yes.
Bidders who fulfill the following requirements shall be eligible to apply. Joint ventures are not accepted. Bidders should have experience of successfully, my lord, that is very important, successfully completed works as mentioned below during the last 7 years ending previous day of the last date of submission of the application. 3 similar completed works, each costing less than 40% of the estimated cost put to tender, or 2 similar works, each cost not less than 60% of the estimated cost put to tender, or 1 similar work costing not less than 80% of the estimated cost put to tender. So, my lord, either they have 3 work completed 40%, or 2 works 60%, or 1 work of 80%. Similar nature of works, so and so and so. The certificate for a successful completion of work shall be issued by an officer not below the rank of executive engineer, project manager, or equivalent, so and so. Value of the executive work shall be brought to the current costing level, so and so, so and so. Now, this is one, my lord. Now, next one is, my lord, your loss will find at page 47.
49.
47, my lord.
47.
47L. This is the I, sorry. I. These are the only 2 clauses, my lord, which are necessary for the purpose of this matter, my lord.
Yes.
The bidder's performance for any 2 works completed in the last 3 years, ending previous day of the last day of submission of this bid tender, should be certified by an officer not below the rank of an executive engineer, project manager, or equivalent in Form D. Form D has not been provided, my lord, here. So this is said, my lord, that there must be 2 works. Value is not mentioned. 2 works, my lord, within 3 years they have to complete. Now, so far we are petitioner, my lord, appellant is concerned. If your loss will find, my lord, first one is, my lord, page 62. The Now, my lord, page 62, your losses, my lord. So for the first criteria of 40, 60 or 80%, my lord, the 3, 2, 1, all. This is one plus certificate, my lord. It covers 80% of the work. This is within 7 years is to be, my lord, done. So far this is concerned, my lord, they have satisfied. So your losses need not, my lord. So I am coming to next, my lord, question. Your losses may come to page 66. The two certificates are required, my lord, as per I. This is one more certificate, my lord. Within 3 years.
Just a moment.
Yes.
From page 45 and 47,
Yes.
you are trying to show that there are two sorts of certificate requests
Yes.
to be given.
Yes.
One is completion and one is performance.
Yes.
Two separate certificates.
Yes.
Okay.
Now, my lord, the first one is, my lord, 40%, 60% or 80%, my lord, in that way.
But completed work.
Completed work, but either 3 work, 2 work or 1 work.
Yes.
My lord. Second one is 2 works, my lord. So here, my lord, page 62, my lord, your loss will find. This is one row certificate. Which we have completed, my lord, or value is much more, my lord, 50 crore and odd. This is one certificate. Page 62.
Yes.
Yes. And second one is, my lord, page 66. Because no permit has been provided to us, my lord, along with the tender. This is the certificate. This is also within 3 years. This is, if your lawsuit will read this, my lord, this is to certify, page 66. The Sri Gautam Construction Company Limited, contractor, 4th floor, so and so, has completed the work with dedicated promptness and planned manner and has fully equipped laboratory at site. Now in the bottom, my lord, again. Okay. 66. Then another one is at 68, my lord. Your lordship got my lord? Page 68, in completion certificate. Certified the following work awarded to Sri Gautam Construction by the Chief Engineer PW Assam. Scope of the job, rehabilitation of bridge over the river, so and so, so and so. The work has been completed in all respect as per specification and provisions to the satisfaction of the department. Now, my lord, in the bottom also again, my lord said overall physical progress 100%. So, my lord, these are 2 performance certificates were submitted, my lord. Now, the observation of the department will also come to my lord. At page 78. B1, my lord, this is Gautam Construction Company, the appellant. First one, my lord, work experience, that first one. Eligible as per Annexure 23, Clause 1A, one similar work costing not less than 80% of the estimated cost put together. So, tender committee was satisfied so far, this only. Now, however, the bidder has failed to comply with the following requirement. Annexure 20A 13(2) Clause 2I bid document, as per which bidder is required to submit Bida's performance certificate for any two works completed in the last 3 weeks. Yes, ending previous day of the last submission of the bid tender certified by an officer not below the rank of executive engineer, project equivalent to Form D. The bidder has submitted only one performance certificate. I love this. What I'm saying. They have said only one certificate. The TC recommends to reject that. So they have not considered the second certificate. We have submitted 2 certificates. Here, these are page 66 and 68. 2 certificates we have submitted. Now, while the learned my lord counsel arguing before a common civil judge, my lord, on behalf of the department, they submitted that, my lord. The second certificate is not a performance certificate at all. They have, my lord, the committee report is different. Committee report says I have submitted only one. Both are, my lord, completion certificate. Both are completion certificate. And language is very clear in both, my lord. But they stated that only one performance certificate is submitted. But here, my lord, they have submitted that the second one at page 68 is not a performance certificate. Only because the good, very good, these are not written. My lord, I have already submitted, my lord, that the Form D has not been annexed to that tender. So in what way, my lord, we have to submit that is not there. And on this ground, my lord, my petition has been rejected. Now, my lord, what happened? After the rejection of the writ petition, when the work order was issued, my lord, all the documents were available because earlier, my lord, my technical bid was rejected, so all documents were not available. Then, my lord, we find that the bidder in whose favor, my lord, the award has been given, my lord, he failed to comply with the first clause, my lord. If your lordship takes up my additional affidavit at page 104, my lord. So that is why I filed this additional affidavit where both parties have result. Your lordship got it, my lord, additional affidavit.
Yes.
Yes. At page 108, if your lordship comes, my lord. This is the, my lord, document they have submitted for this 80% work. One. To whom it may so and so and so. Here, my lord, work is 98% complete. Work is 2 100%, 3 is 98%. So it is not a complete, my lord, work. They have ignored it, my lord. They have accepted this. Then secondly, my lord, if your lordship comes to, my lord, the other second part of the question, they have submitted some joint venture document, my lord. Where is, my lord, joint venture was allowed? Page 110, my lord, if your lordship. This performance report of works, my lord, here no name has been given, first one 110, but if that you will also find at page 111. This is a joint venture work of 3 persons. Similarly, my lord, at page 112, another parchment certificate has been given. That is also not of the my lord. This is also joint venture. At page 113, if you also find, this is also joint venture. Now, my lord, the department has filed an affidavit.
This page 112 is for whom?
113.
112.
112, my lord, this is as name is not mentioned, my lord, here. Name is not mentioned. Name is not mentioned. They have given a certificate, my lord, they have obtained a certificate for the purpose of the second year. The name is here at page 113, 113. This is up to person, joint venture.
The 110 also this is not there.
No, 110 is not there, 111 is there. Name is not there, but they have accepted it.
111 NGTD Shivam is there.
Yes, 3 persons. 3 persons are there. Northern Gases, Rundotto and Shivam Tasu. So my case is on 2 counts, my lord. First thing, I have complied with all the requirement. My second certificate is also valid, my lord. That was passed aside on the argument of the learned counsel, my lord, the department, that it is not a performance certificate. Department has filed an affidavit, okay, my lord, in this matter, that is in reply, my lord, that is the main, yes. If you also find, my lord, it's page 121. That is in play. 121. So for their reply is concerned, my lord, which is at page 124. 124.
Yes.
It is submitted that above clause pertains to work experience of the bidders where and bidders are required to have successfully completed relevant works amounting to SCC value. The respondents have submitted a work experience document amounting to rupees so and so. This is my private respondent of so and so, which is more than 80% of tender value. Hence, respondent number 7 has the work experience as required in above clause. Completed, my lord, it is not said in the completed. The appellant assertion that clause 2A of the demand bidders should have experience of successfully completed works, whereas the certificate published by the respondent 7 clearly testifies that the physical progress was 98%. And coupled the same, the certificate also does not contain the performance certificate for above work, which is alleged ground for rejection of the technical bid submitted by the appellant herein. It incorrect, as respondent 7 has submitted a work experience document wherein where it is certified that respondent 7 has successfully completed a work amounting to rupees so and so, which testifies the requirement of above clause. Further clarify that technical bid of the appellant was rejected for non-compliance of so and so 2I and not for regional, etc. So far, other two things are concerned, but nothing has been said. Regarding the Sundar 7's, the two certificate, my lord. Regarding. Now, my lord, if your losses takes up, my lord, the affidavit position, my lord. I wanted to take up to your losses at para 9, my lord. That is only one
Para 9
of the affidavit position. Affidavit position, page, it starts at page 129. Para 9 is at page 134.
Yes.
Well, that it refers to statements made in paragraph B1 admitted the same are submissions made by the appellant when came to which did not find favorable analysis. It is submitted as per annexer 20A 13.2 2.2I. The bidder's performance for any works completed in last 3 years ending previous day of last day of submission of the bidder should be certified by an officer not below the rank of executive engineer, project manager equivalent to Form D. The submitted performance certificate evaluates the performance of the contractor on the following parameters. Well, these things are neither in the tender nor the quality of the work, financial soundness, my lord. These things are not there. But my certificate, my lord, overall everything is here, my lord. If you also will see again, my lord, to the certificate, this is the my lord, allegation they have made in the before the single judge also. Now they have made this.
But then these things you could have pointed out when the evaluation of the tenders were being made. Is it a proper time to raise an objection?
My lord?
You see, when the documents are evaluated,
yes,
the objections are required to be raised then.
So this is in respect of me, my lord. They say they have rejected my second certificate on this ground. Said that this should be, but in the tender document, nowhere said that these things are to be there.
Okay.
Because if your losses, see my two certificates again, my lord. At page 68. At page 68 and 70. 66 and 60. Page 66 and 68, my lord. Both certificates are, my lord. Actually, language, whatever language is there, language is so now, my lord, they wanted to develop by an affidavit or statement before this court, my lord. Whereas the technical evaluation committee, my lord, they have said only one certificate I have submitted. They have not said two certificates. They have not said anything about the second certificate. Now, before the court, my lord, they wanted to say that this is not a certificate. Whereas this certificate is very much clear, work has been completed in all respects as per specification and provision and to the satisfaction of the department. My lord, what more is required? I do not think so. In the page 68, my lord. And bottom also, overall physical progress 100%.
How is this issue dealt with in the
Hello?
writ petition?
Lordship, we come to page 92.
92.
92 is
Yes.
from paragraph 11. Lordship.
Yes. Para 12, my lord. The work completion certificate submitted by the petitioner in respect of the work getting so and so has provided the following parameters under which the petitioner performance has been judged, which is reproduced below. My lord. However, the work completion certificate dated 30/11/22 for the work revelation so and so over reval goal so and so does not have any performance report on specific particular parameters when compared to earlier work completion certificate. The work completion certificate states the work has been completed in all respects as per specification, provisions, and the total satisfaction of the department. Well, what more is required? I don't know. My lord, language may be fine, my lord. They have not given any format, my lord, that this should be the format. They have not given any format. And technical committee, my lord, have said only I have submitted only one certificate. They have not said that this is not a certificate. Nothing, my lord. They cannot improve the case, my lord, by filing an affidavit or saying something before the court, my lord. What is there in the report, that is the main question. Police commissioner case, my lord, they followed till now, my lord. And secondly, my lord, the response number 1, my lord, these documents are not available to us, my lord. Response 7. Only after award of the contract, my lord, is available because my technical bid was rejected. It is not available. Now we come to know that so far 80% work is concerned, that is not a completed work. And they have a separate.
But when the documents were evaluated, you are
no, we are not allowed to give, my lord. We are not allowed. We are not allowed. The technical committee themselves see, my lord.
Objections to the documents are not allowed to be made.
Not.
See this tender document. Where is there a bar?
My lord?
In the tender document, does it say that the
no, these documents are not available to us, my lord. These documents are not available to us.
If I may, Lordship, these documents were available to all the participants from 5 to 2025, Lordship. The statement made by my senior is not correct, Lordship, because after the technical bid was open, Lordship.
Let him complete, then
Yes,
you can
yes,
take his own.
My lord, I have this affidavit I have filed, my lord. These documents were made available to the appellant, my lord, only after the work was awarded. And since our technical bid was rejected, these were not available to us.
Where is the comparative statement?
Yes, my lord, that your loss is fine in a petition, my lord. Not competitive statement, technical bids, my lord, that is. Competitive statement, my lord, because that is not a, they have only technical bid, my lord. Financial bid is not there now. Financial bid is different, my lord. That page 73 onwards, my lord, so far financial bid is concerned, we can.
Okay, where is the technical evaluation report?
At page 73 onwards, my lord.
73.
Yes. And they have examined it, my lord, at page 77 onwards. Work experience criteria. The MP Agarwala first. Found that bidder has submitted work experience certificate following work. The work was completed on so and so, hence, and its value so and so. Now, this is MP Agarwala. So now, so far, MP Agarwala is concerned. So far, MP Agarwala is concerned, my lord, it was said that the work was completed on so and so. So that was there. But so far, item number 2, Tarun Dutta is concerned, the other 7. They said embankment construction or flood construction 39.68 crore. The bidder is found to be eligible as per Annexure 23(1). One similar work is costing so and so. Nowhere they have said that is a completed work. Whereas per the tender criteria, it must be completed work. And so far the other 2 certificates, they have not considered, madam, here. So what Tarun Dutta is concerned, 23, very peculiar manner how they have done it, technical bid. Embankment construction of 39.68 crore. The bidder is found to be eligible as per clause 23 AI. One similar work of its costing not less 80%. Well, the second one. Second is not considered at all. So far he is concerned. First one is also not completed work. They have not said anything. Second one is, well, so far part 2 is concerned, well, this second part they have not considered at all. So far, Resolution 7 is concerned. They have only considered 1A. 2I has not been considered at all. So Resolution 7 is concerned. So, well, absolutely, my lord, the technical committee was totally, my lord, done in a different manner altogether. Just to, my lord, award the work to him, my lord. Because completion work is also not mentioned here. In other cases, completion work is mentioned. So, my humble submission that, my lord, here, in a very arbitrary manner, my lord, the technical committee has done, my lord. In this aspect, my lord, I should test 2 judgments of the expert, my lord. First one is, my lord, that 24 AR Supreme Court 5314. I'm given from Supreme today.
24 refund.
AR 24 5314. Paragraph 19 to 21. First, my lord. Hello. Paragraph
Ye-
19 to 21.
You are referring to which case?
This first case, my lord, the Supreme today.
MP power.
No. My lord, other one. Bansidhar construction.
Banshidhar construction.
Yes. Paragraph 19, 20, 21, 29, 20, 30. 5 paragraphs. Next are almost similar, my lord, here. May I please? Para 19, velocity particle.
Please give us again paragraph.
Paragraph 19, 20, 21, and 29, 30. 5 paragraphs. May I please, my lord? It would be, may I please, my lord?
Yes.
My lord. Paragraph 20, 19. It would be apposite to note that as per section 2 of the Power of Attorney Act, the owner of a power of attorney may, if he thinks fit, execute or do any instrument or thing in and with his own name and signature, his own seal, where sealing is required by the authority of the donor of the power, and every instrument or thing so executed and done shall be effectual in law as if it had been executed or done by the donee of the power in the name, with the similar signature seal of the donor thereof. In the instant case, POA was duly executed in favor of donee. The signatory of the documents was duly notarized before the with submission, along with other important documents required to be submitted as per NIT of the balance before the last date for submission fixed by the respondent BCCI. Hence, there is no legal or justifiable ground to reject the technical bid of the appellant. Thus, the said action of the respondent BCCI in rejecting the technical bid of the appellant on absolute extraneous ground and accepting the technical bid of the respondent number 8, those submitted in utter non-compliance of the mandatory requirement of clause 10 of the NIT, and subsequently calling upon the respondent number 8 to furnish the shortfall of the documents after opening of the technical bids of the bidder, was totally arbitrary and illegal. Well, same thing, my lord, here. Now, there cannot be any disagreement with the legal propoundant.
Certificates. Page 62. 62.
There cannot. 62, that was accepted, but 66 and 68, my lord, so far 68 is concerned, they have not. Received. 68, 62, my lord, that confirms, my lord, 80%, yes. That confirms. They have accepted it. So far that is concerned, my lord, there is no objection. Yes, clause is, my lord, 21A. 21A1. Yes. Yes. One. Other two documents are page 66 and 68, my lord. This should be within 3 years and the other one within 7 years. It's clear. Yes, my lord. And my lord at page 45 and 247. Beautiful. My lord, I am placing the judgment, my lord, at paragraph 21, my lord. There cannot be any disagreement with the legal proposition propounded in getting of decisions of this court relied upon by the learned counsel for the respondent to affect that court does not sit in a court of appeal in a matter of award of the context and is merely review the matter in which decision was made, and the government instrumentally must have the freedom of entering into context. However, it is very well settled that the decision of the government instrumentally must be free from arbitrariness and must not be affected by any bias or actuated by malafide. The government bodies, being public authorities, are expected to
You
uphold
are
the
reading paragraph?
21, my lord. 21.
Oh, acha, in the, okay.
That judgment, my lord. I'm sorry.
Okay.
The judgment
I was reading the impugned judgment.
Oh, no, I'm sorry, my lord.
No, it's okay.
I'm placing that paragraph 21.
Yes, yes, yes. Yes, yes, please proceed.
There cannot be any disagreement to the legal proposition propounded in the canon of decisions of this court relied upon by the learned counsel for the respondent to the fact that court does not sit in court of appeal in a matter of award of the context, and it merely reviews the manner in which the decision was made, and the government or instrumentalities must have a freedom of entering into a context. However, it is equally well settled that the decision of the government or instrumentalities must be free from arbitrariness, must not be affected by any bias or actuated by velocity. Government bodies, being public authority, are expected to uphold fairness, equality, and public interest, even while dealing with the contextual matters. The right to equality under Article 14 aborts arbitrariness. Public authorities have to ensure that no bias, favoritism, arbitrariness are shown during the bidding process, and the entire bidding process is carried out in absolutely transparent manner. Then paragraph 19, 29 and 30, my lord. Last page. The submission made by the learned counsel for the respondent that the project in question being infrastructure project and also one of the mega project, this court may not interfere more particularly in view of the fact that agreement has already been entered into within the respondent BCCI and a special purpose vehicle of the respondent number 8 cannot be accepted. When we found that the impugned decision of the respondent BCCI was grossly arbitrary, illegal, discriminatory, and violative of Article 14 of the Constitution of India, as held earlier, the government bodies instrumentalities are expected to act in absolutely fair, reasonable, and transparent manner, particularly in the award of the contract for mega projects. Any element of arbitrariness or discrimination may lead to the hampering of the entire project, which would not be in the public interest. In that view, in this matter, the impugned decision of the respondent number BCCI, that is so and so, rejecting the technical bid of the appellant and further declaring the respondent number 8 as a successful bidder is set aside. And the action process undertaken by the agreement in pursuance to the said decision also stand set aside. It shall be open for the respondent BCI to initiate a tender process for the project or to process the same in question according to law. My lord, here also virtually same thing, my lord, that the private respondent's, my lord, bid was accepted and the appellant's bid was rejected arbitrarily, my lord. Both things. In this case also same thing, my lord. The first condition has not been complied with. Second is also not complied with actually, my lord. Now I am arbitrariness, my lord, on the point of arbitrariness is that this decision, my lord, MP management, my lord. 73, 74, 75, my lord. Only 3 paragraphs on arbitrariness, my lord. My lord.
Let's say if we keep it in decision level.
Yes.
Respondent number 7.
Yes.
Has completed 97. This person not.
Respondent, yes.
Yes, where is
my lord, at page 108, my lord.
108.
8, their certificate, my lord, which you submitted there. This is not completed work, my lord. And that is why tender committee, technical committee has also not commented anything in this letter.
So who has awarded the work?
This person, my lord, Tarun Datta.
Tarun Datta.
Yes. This is not a completed work. As per 2A1, my lord, he is not qualified. I have already placed the technical committee, my lord, finding. Technical committee accepted this one and he said nothing, my lord, so far second part is concerned. So far Toronto is concerned. Because the two other certificates were also not only of him, that was joint venture. The 110 and 112, these are of joint ventures. 110 and 112, no name is there. Well. Now, my lord, you'll also seen, my lord, that technical evaluation was not properly done, my lord. So far as soon as 7 is concerned, only A1 has been considered. So far I is concerned, my lord, they have not considered at all. And he was technically qualified. So far I am concerned, my lord, they said only one partner certificate is submitted. Although we have submitted 2, they have not commented on the second. Now, arbitrariness, my lord, I just rely on 3 paragraphs of this judgment, my lord. 23 2 SCC 703. 73 to 75. Others are also there. Yes. The 73, they have referred to, my lord, this Srilekha Vidyarthi case, my lord.
We'll take into consideration because we did not notice the words.
Yes.
Because this is not a regular bench. We may not be carrying it tomorrow.
My lord.
So that's why.
Yes.
We'll take into consideration this.
My lord, yes, I am not. Now, my lord, I am placing Black Law Dictionary. What is performance for the certificate? 5th edition, my lord. Maybe. And one more then. My lord, performance, my lord, as per this, my lord, the fulfillment or accomplishment of a promise, contract, or other obligation according to terms. The lawsuit document?
Yes.
According to terms, this is the, my lord, performance. So, this certificate are very much, my lord, in accordance with this, my lord, my certificates. Hardly, my lord, I am relying on this 1310 SCC page 95, only one paragraph, my lord, paragraph 18. On one count, my lord, that if they have found that there is something missing in the certificate, they would have asked me. Because form has not been prescribed along with the tender. Let's say fact. Paragraph 18. The lawsuit got well?
Yes.
Paragraph 18, my lord. We think that the income tax return would have assumed the character of an essential item if one of the qualifications was either gross income or net income on which tax is attracted. In many cases, this is a salutary stipulation since it is indicative of the commercial standing and reliability of the tendering entity. This feature being absent, we think that filing of the latest
But
income
after this
return.
judgment, there is a paradigm shift of the
My lord?
way in which the Supreme Court has evaluated tender matters.
Yes. Anyway, my lord, I am not. First thing, my lord, I am going arbitrating on this, my lord. That is my question, my lord. So far, respondent 7, my lord, that was not considered properly, my lord, the tender evaluation, technical evaluation committee, and my case was also not evaluated. They have said I have submitted one certificate. This is my case, my lord. Exactly, my lord, the case, like, my lord, the other case I have cited, my lord, this considered constructive committee. Much well.
Yes.
If I may take your lordship to the judgment passed by the learned single judge, which your lordship will find operative portion, it starts from page 87. Now, what my learned friend was aggrieved before the learned single judge was the rejection of his technical bit. And the prayer of the writ petition, lordship will find at page 37. It's only the rejection of his technical bit. The points that were urged before the learned single judge, my senior had confined his arguments only to the document at page 68, which, according to him, is a performance certificate. Now, Lordship will see page 68. It is a completion certificate of a particular work where nowhere his performance is evaluated, unlike the document at page 66. Unlike the document at page 66. 66, it makes some evaluation. Whereas the document at page 68, there is nothing of that sort. And the only issue that was framed by the learned single judge, based on the arguments advanced, is at page 90.
This is a
If I may take your lordship to page 90. 90 of the, that is a part of the judgment of the learned single judge. Paragraph 8. The issue to be decided is whether the work completion certificate dated 30/11/22, that is at page 68, submitted by the petitioner can be said to be a bidder's performance as required under Annexure so and so clause 2(1) of the bid document. Now, to 2I, I'm sorry. 2I, your lordship will find at page 47. The bidder's performance for any two works completed in the last 3 years, ending previous day of the last day of submission of this bid, tender should be certified by an officer not below the rank of executive engineer, project manager, or equivalent in Form D. Now, the document at page 66, not wrong, I'm sorry, page 62 evaluates his performance, but this is a certificate of 2019. It does not fall in the criteria of the last 3 years. This is for a previous period. So for the last 3 years, he has to submit 2 certificates, and 66 and 68 are the 2 documents that he had submitted in this criteria. 68 does not reveal by any means that there was some performance evaluation. So far as performance evaluation is concerned, yes, he is right in one sense that no standard format has been given, but it can be an evaluation of any means. It has only to speak for itself. It does not require a particular format in which it has to be given. So therefore, this certificate at page 68 in my humble submission does not evaluate his performance in any matter, and this cannot be taken to be a certificate that is to be issued in pursuant to that particular clause, clause I, 2I. And it has been rightly rejected.
Mr. Jury,
Lordship.
though before the single court in the writ proceeding, respondent number 7 and respondent number 8 were implemented as party respondents.
Lordship.
After flipping through the pages, I saw that there is no averment, subject to correction by Mr. Sahil, that there is no averment that their bids were
It is not
incorrectly accepted
has-
or
yes.
wrongly accepted.
He has not challenged that. That is why I.
So the writ petition has been decided.
Yes, Lordship.
Now, the matter has been carried to this bench by an intra-court appeal.
Lordship.
Now, subsequent information
Lordship.
by way of additional affidavit,
Lordship.
how it is to be
MS Gill.
treated.
MS Gill. Now, whatever.
No, that is an order. That is an order passed by an authority.
Yes, yes.
Is to be tested with the regions assigned.
Yes, yes.
Right?
Yes, yes.
That cannot be supplemented. Additional region cannot be supplemented
Lordship.
by way of an affidavit.
Lordship.
That is something different.
Lordship.
Now, writ proceeding has been concluded by an order.
Lordship.
At that point of time, the defects now shown by the appellant were not shown.
In my humble submission, it will be a cause
So
for a
this is
fresh writ petition.
Huh?
In my respectful submission, it will be a cause for a fresh writ petition.
No,
Because,
cannot be. The issue
because,
is,
because these were not the facts which were argued or pleaded before the
so in
learned
an
single judge.
inter-court appeal, what is to be? This is also not subsequent development.
This is not subsequent development, but this was not before the learned single judge. This was not before the learned single judge, and that was not the line of argument before the single judge.
I need to take the writ petition. If you have that additional affidavit, inter-court appeal. There is a law then.
But still, Mr. Saibala says that it was not in public domain and therefore no objection could be raised.
I have made a statement, Lordship. As soon as the technical bids were open, it was open to all the bidders. He cannot say that I did not know.
Did not know is different. If it is open, open.
It's open for all.
He did not examine, that is a different.
That's another aspect.
Whether it is open.
It's
It was
open. It's open.
How do you say that? From what document?
Lordship, I make a statement in my additional affidavit, Lordship.
Additional, where?
Yes, I'll just take a look at that. What was for affidavit, keep on? At page 122, Lordship. At paragraph 4, Lordship. Page 122. Page 122. paragraph 4, Lordship, that with reference to the statements made in paragraph 2, the deponent begs to submit that the assertions made therein are not correct. It is submitted that the participating bidders are able to assess the bid documents submitted by the bidders after opening of the technical bid. In this case, the technical bid was opened on 5/2/25. Hence, all the participant bidders had access to each other's documents since 5/2/25.
Is there any?
No, Lordship. Now, since the pleadings and the arguments were only based on whether the document at page 68 would spell out his performance or not, that was the only issue framed before the learned single judge. And my senior had omitted paragraph 11 of the judgment. He did not read it. How the learned single judge has dealt with it? A perusal of the Annexure 20A 13.2 clause 2I of the bid document clearly goes to show that the bidder's performance in two works completed within the last 3 years from the last date of submission of the bids has had to be submitted in the bid by a tenderer. In fact, Annexure 2A 13.2 clause 2I of the bid document requires a scanned copy of the performance report to be uploaded. As such, it is quite apparent that the performance report is the basic requirement required in terms of annexure so and so. While one of the documents spells out some performance, the document at page 68, Lordship has seen, there's nothing like that, Lordship. And it has been rightly rejected, Lordship. And it is not a case, Lordship, that only his tender has been rejected. Some other party's tender has also been rejected on the same ground. I was referring to 68, Lordship. Or 66. Court, huh?
25 January. 25 January 25.
Court लिखिले.
Actual date of operation.
तो माझं तसं ना? हा. Yes. That is so far as Lordship, the document is concerned, Lordship. I would humbly submit, Lordship, that has been rightly rejected. It does not reveal anything at all. It is only a completion of that work. Completion, we would not say that he has not completed. He might have completed, but that cannot be taken into consideration in terms of the tender clause, Lordship. Now, of course, Lordship, he has come up with some additional grounds in the additional affidavit. If your Lordship would like to delve into that, because so far as my submission would be, Lordship, we would rather be confined to the arguments which were advanced before the learned single judge. Now, additional some points he has raised so far as documents submitted by respondent number 7. Now, perhaps, Lordship, the submissions made by my senior would not be correct. He says completion, that whether the respondent number 7 has completed the works or not. Now, if I may take your Lordship to page 45 for a moment. to A1. He was raising an objection in particularly with respect to this point. 3 similar completed works. Lordship will mark 3 similar completed works, each consisting not less than 40% of the estimated cost put to tender. That is one part. Second part is 2 similar works. It is not completed works. 2 similar works, each cost not less than 60% of the estimated cost put to tender. And there is another part, or 1 similar work costing not less than of the estimated cost put to tender. In the subsequent 2 categories, it is not completed works, whereas it is completed works so far as where the petitioner had to submit 3 certificates. So that would take care of his submissions. And in so far as Lordship tender matters, my senior has placed a few judgments before this honorable court. Now, Lordship, in tender matters, until and unless it is very arbitrary or malafide, the Supreme Court says that normally the writ courts would not like to interfere. And in a latest judgment of the Supreme Court, Lordship, I am not carrying a copy, I'll just give the citation. 2022 6 SCC 127. (22) 6 SCC 127. It is NG projects. NG projects. 127.
NG projects.
Now, the Supreme Court has gone ahead and now a new interpretation is coming that Lordship towards the end, in my Supreme today, it's 23. In view of the above judgments of this court, the writ court should refrain itself from imposing its decision over the decision of the employers as to whether or not to accept the bid of a tenderer. The court does not have the expertise to examine the terms and conditions of the present day economic activities of the state, and this limitation should be kept in view. Court should be even more reluctant in interfering with contracts involving technical issues, as there is a requirement of the necessary expertise to adjudicate upon such issues. The approach of the court should be not to find fault with magnifying glass in its hand. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender condition. If the court finds that there is total arbitrariness or that the tender has been granted in a malified manner, still the court should refrain from interfering in the grant of tender, but instead relegate the parties to seek damages for the wrongful exclusion, rather than to injunct the execution of the contract. Now, it has gone a little bit further than what it was before. Even then, Lordship, in the present case, Lordship, there has been no violation of the tendering conditions, Lordship. It is for him to make out a case that no, I was illegally or arbitrarily, I was wrongfully deprived. Now that is not his case. The documents will speak for itself. Whether the document at page 68 is performance. That is my humble submission.
Yes, you don't have to say anything. Well, perhaps adopt what
He's the
Mr.
beneficiary.
Chaudhary says.
He's the beneficiary. He should.
Beneficiary, but only my question is, Lordship, my Lord has already rightly pointed out that I have filed an affidavit raising the preliminary objection regarding the new grounds, additional affidavit, whereby he has brought some allegation against me. But in the writ proceedings, there's no any whisper against me. It is a purely case against the authority concerned, decision-making authority. Now, in the appellate of the state, he has taken a new ground. That is my objection. And secondly, my Lord, he is technically rejected in 10 to 2025, February. But all bidders aware about the rejection and allowing the technical bid. That he was sitting tight. When LOA issued in favor of me on 8/5/2025, then he has came to this honorable court.
Just give us the dates.
Yes, my Lord. The technical bid rejected on 10 to 2025.
Yes.
LOA issued in my favor on 8/5/2025.
Yes.
And he moved this honorable court on 19/5/2025. On 20/5/2025, the work order issued in my favor. And because this is a time-bound project, the authority instructed me to start the work. Accordingly, I have started the work, and work is going on full swing. Because this is a protection of Majulia from flood and erosion.
But as per your documents, you are an expert in tree felling.
Yes, my lord. This is not
What do you-
that objection. There is nowhere mentioned in the NIT that that may not be accepted.
Okay. But that's anti-conservation, conservation. You're expert in anti-conservation.
Question is delay of filing this writ petition. This is another question. And whatever this arbitrariness, irrational and unreasonableness. There's nothing found in this, my lord, decision of the Honorable Single Judge. The Honorable Single Judge has rightly taken a decision, my lord.
My lord, I shall take only 5 minutes, my lord. My lord, here, the Technical Evaluation Committee, he sat on 8th May 25. Your losses will just move down, at page 73.
Minus.
Not February, my lord, what my lord.
Technical
Evaluation Committee evaluated the, my lord, tenders on 8/5/25.
Okay.
Page 73, and it was uploaded on 9th May 25 at page 83. Rejection, my rejection has been rejected.
Uploaded on 9.
9/5. Page 83. Page 83. So it is wrong, my lord.
Interim order 13.5.
Ah.
Interim order is 13.5.
Interim order is on 13/5, my lord.
Final order 16.5.
And final order 16/5. And my learned friend said Gill's case, my lord. Gill's case is applicable to him, my lord. Because in the Technical Evaluation Committee, my one certificate, they have found only one certificate. The 2 certificates, they did not find it. And so far, Respondent 7 is concerned, they have only considered A1, not the I. I had not been considered at all. And so far, my lord, the completion certificate, my lord, that your lawsuit page 45, my lord, my learned friend has not read A, page 45. Your lawsuit is to read the entire thing, my lord. He said only in respect of 40%, not correct. A. The bidder should have experience of successfully completed work as mentioned below during last 7 years ending previous day of the last submission of the application. So this is the main clause, my lord, which qualifies it. So what my learned friend for the department has said, this is not correct, my lord. That the completion is not required. So far, 80% is concerned. It's a totally arbitrary manner, my lord, this has been done. Technical Evaluation Committee report, my lord, absolutely arbitrary. So far, A2 is concerned, my lord, Respondent 7 is not consideration, and in my case, only one certificate time. And now they have come up with some new argument, my lord, which is against, my lord, the police commissioner or Gill's case, my lord. Because while the single bench disposed of the matter, my lord, without any affidavit, without anything, my lord, it was that is why division bench directed him to file the affidavit, my lord.
I'm sorry, Lordship. Perhaps has fallen from my senior. I've clarified that point. Lordship will see page 124. Affidavit in reply. Affidavit in reply. The second paragraph, the respondent number 7 submitted a work experience document amounting to so and so. which is more than 80% of the tender value. Hence, respondent number 7 has the work experience as required by the above clause. Now, the appellant's assertion that clause 2(1)(a) demands that the petitioner should have experience of successfully completed works, whereas the certificate published by the respondent number 7 clearly testifies that the physical progress of the work was 98%, and coupled with the same, the certificate also does not contain the performance certificate of the above work, which is the alleged ground of rejection of the technical bid submitted by the appellant herein, is incorrect, as the respondent number 7 has submitted a work experience document where it is certified that the respondent number 7 has successfully completed the work amounting to so and so, which satisfies the requirement as per the above clause. This is completion certificate. This is not that performance. It is further clarified that the technical bid of the appellant was rejected for non-compliance of annexure so and so, and not for the reason stated above. Performance is one part and completion is another.
Summary report in the DMOE procurement system.
Lordship.
Technical bid opening count.
Lordship.
Summary technical bid open on 5/2020.
Lordship.
Whether that statements are open for all to see. They find updated on 5/2020. But thereafter, technical evaluation summary details.
Lordship.
On that day, all documents are open for inspection for all.
Yes, Lordship.
That statement in your availability is related to this part.
Lordship. It was available for all to see. On, oh. And the minutes of the meeting of the tender evaluation committee, Lordship, will find at page 76. 76. If you're yes.
The Bora says that technical bid was rejected on 10-2.
Yes, one.
Yes,
If 10-2 is
Lordship will see page 76 because
70.
76. 76. Top. Top. First
That we are seeing.
Yes.
Second line, 10 February.
That's why we asked this question. We're asking this because
Ask this question.
Yes. Yes, Lordship.
Whether the fate of his bid
Yes.
was known to the petitioner or appellant.
That I have made a statement, Lordship.
When, on which day?
No, that
When it was open for all to know that the fate of their bid.
I was referring to page 122, paragraph 4. And I say, in this case, the technical bid was opened on so in 5/2. Hence, all participant bidders had access to each other documents since 5/2.
can't be.
Can't be.
Page 83. It cannot
You
be.
can come to page. The summary.
Yes.
That's why we're asking that question.
Lordship, I'll get a clarification. Lordship.
You've seen page 83.
None.
Document is none. And then second technical evaluation of 9th May, now you get document so and so PDF.
Lordship is read.
Page 83.
PS table,
Ah.
9/5.
Technical open bid summary table.
Yes.
last is document none.
Huh.
So if there is no document in the in your system, you can't show it. So that statement of yours may not be correct.
I'll have to get a clarification.
And then second is last box is technical evaluation.
Hmm.
Here you find that there's a document of 5453.55 KB.
Lordship. I'll get a clarification on this, Lordship. Yes, there is a mismatch of the dates. I'll get a clarification on this.
On 5/2/2025, whether the bidders
Yes,
were aware as regards acceptance or rejection
No.
of their technical bids.
no.
No.
Because
Here, technical bid was opened. Must it?
That is what,
Huh.
because Mr. Bora had submitted,
Yes.
that fate of petitioner's bid was known on 5/2/2025.
No, perhaps
That's why we have.
he is not correct, because here we say only the documents were.
no, he's the beneficiary, he has to be correct.
I said this too.
This
And
I'll get it.
I
no,
think
the second part is
Yes,
that we are evaluating just because
Yes.
Mr. Bora said that.
yes.
Otherwise, we would have omitted all these things.
Lordship.
The fact is that the technical evaluation is on 8/5. It is uploaded on 8/5. And the LOI is issued on 8/5 before that. That means what you do is unfair. You see, LOA, Mr. Bora says, is issued on 8/5/1995, 2005. That is a specific statement.
तो अपना भूल से ना कि कुछ तो ऐसा होता है रिसोर्ट
No, I don't think so.
perhaps is
I will apply for it.
Correct. It
Correct,
is
it's
uploaded on 9/5. That
Maybe.
means says,
because I distinctly remember, Lordship, it was after the courts.
and you see, we have complied with the Supreme Court judgment. We have
Yes.
not used magnifying glass.
That date I will get it clarified.
Page 75.
Yes. Lordship.
8/5, it is clear. MP Agarwala, Northern Gases.
This one.
But what about Gautam Das part? Because MP Agarwala Northern
This-
Gas
This
committee recommended following actions. Yes.
this is
Earnest money forfeited, bidders shall be debarred from participating in future. Tendering. One is Torun Gautam, wrong with the infrastructure.
no, Lordship, this
What
page
about
is
Gautam Das?
this pages, Lordship, have come upside down. Here, Lordship, page 76 is a meeting 10-2. 10-2. Thereafter, this document should have been there. It's 8/5. Yes,
No.
76, I have seen.
You
Page
see-
76,
yes,
first line, minutes of the first meeting,
first meeting.
right?
Yes, and
There on that day, Gautam was out,
Gautam was out.
then 80, minutes of the second meeting.
Third meeting is page 73.
Then
Yes,
second meeting.
Third page is page 73, and this is very perfect because page 73 is 1/3. Second, page 74 is 2/3, and other is 3/3. So complete.
Hardly. So whether that Gautam's bid was not accepted on first meeting itself, right?
yes, Lordship.
So whether it was informed to them, then day, 10th February 2025.
Because somebody doesn't say uploaded.
Somebody says nothing.
So therefore, you have withheld his rejection from first meeting, which was on That 76,
Yeah.
Third meeting,
the third meeting, you have withheld that.
That I'll have to take a little clarification whether he was informed or not.
You'll be hit by this MS Gill who cited.
That will have to take instructions.
No, but we may not give you that opportunity. We'll close it. You don't, because we will not be sitting. It's we may not be. We will not be. We may not be there together.
No, sure.
And that division bench has applied, what is subject to, that is almost less.
Okay. The submissions of Mr. G. N. Sayola, and senior counsel, assisted by Mr. M. Sayola, and counsel with the appellant, Mr. R.K.D. Chaudhary, and you are appearing at DSGI
Yes,
or
yes, Lordship.
at DSGI, done it. DSGI
For 1 to 6.
for respondent was 1 to 6. This was 7.
And 7, my friend.
And Mr. R.K. Boral and counsel for respondent was 7. It's concluded. So judgment is out. 8 is not.
No,
It has not.
No. Not getting to this.